talk shit. Couple nights to gasoline on the fire. We never knew how to perfect. We always knew it would work, cause if something misread, if something got said, before the night ends. No, don't get stressed, it's gonna get figured out. Oh, the conversation that don't happen else. Headstrong father and a determined mother. Oh, that's why some nights we try to kill each other, but you know it's always love. You never knew how to fake it. We always knew how to break it. Couple nights, no gasoline on the fire. Something misread, something got said. All the night end. No, don't get stressed, it's gonna get figured out. Oh, deep conversations I don't have enough. Headstrong father from under shining light. Oh, that's why some nights we try to kill each other, but you know it's always love. La, 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 la. Oh, la, 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 la. You know it's always love. La, 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 la. Oh, la, 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 la. You know it's always love. Deep conversations at the Waffle Lounge. Headstrong father and at the time. That's why sometimes we try to kill each other.
What's good? What's good? What's good? Can y'all hear me? Let me do my own test. What's good? What's good? What's good? Yeah, that's that feel good music. Let me see if I can.
What's good? What's good?
Oh, damn. Y'all can hear the fan and every goddamn thing else. Hold on. Oh, damn. Y'all can hear the fan and every goddamn thing else. Hold on. Okay, so I got background noise. I got an echo. Hey, what's good? What's good? Okay, so let me do something with this echo. Background noise. All right, let me see what I got now. Testing. All right. Testing. Okay. Hey. Okay. All right. Trying to work with these mics, y'all. Let me see who on the record tonight. Hey, Shawty. Hey, Open. Hey, Queenie. Hey, Purple. Okay. So, listen, y'all. We got a lot to go over tonight. We got a lot. We have I got to go over again. Lord, our Kelly's oral arguments again. Because we have people that like to come out and lie the record all up and fuck it up, and guess what y'all do? That drives me absolutely crazy. Y'all come ask me, just clear it up, straighten it out. Instead of asking the people that's telling you the wrong shit to straighten it out. But I guess it would only be doubling down on some more incorrect information or some lying ass shit. So I guess that's neither here nor there. So guess what I'm gonna have to do? I'm gonna have to play that all over again and break it down again. And sometimes what when I do have to redo it or repeat it or whatever, sometimes I get to elaborate on pieces maybe that I missed or maybe that you need clarity about because I got emails and shit asking me to clarify what somebody else was saying, other people saying. I'm like, what? Oh my God, what up, Diva? Like, damn, that's no. And I think I'm gonna try real hard. I hate to be chewing. Yeah, but I'm hungry. I'm gonna try real hard to at least bring you something from the Nature Boy trial. 'Cause I went and got that paperwork too. There's also a rapper called Cash Out. Apparently, he is an Atlanta-based rapper who has some songs out, sung out with Future and some more people. He's caught up in an indictment, perfect for this sector because it has something to do with prostitution, right? So I got to get the paperwork on that. Yeah, I've been busy the last hour. What up, Cookie? What up, Cookie? Yes, ma'am. Hey, DV. Yes, a lot of stuff going on. So yes, everybody, and I played that song, and that song is called Waffle House by the Jonas Brothers. It's one of those songs I believe any culture can vibe to. The message is pretty clear. I know a lot of times a lot of people doesn't don't have a specified religion, right? But we do receive some type of healing through music and what have you. You know what I'm saying? Whether it's rap music or whatever to get you upbeat in your tempo and all of that, whatever, or it's a feel good song like that. There's a message somewhere, somebody, right? And if you read the words of that song, you'll see why I played it. It's one of those, hey, it's always love, man, and you'll get it figured out. At the end, it works out. But yeah, so there's a lot going on. Yeah. Oh my gosh. When I saw that P. Diddy, this latest P. Diddy paperwork, Charlie got Stevie J on there. And guess what, y'all? We got pictures, folks. Yes, we do. Yeah, we do. So make sure y'all get y'all little stuff together. Get y'all little drink and weed or whatever it is you use to stay tuned. Because, baby, we're going to be here. But let's do the oral argument again. Oh, I can't. And what be so funny? These be people that be coming at my credentials. Huh? How is that, what? When you don't know what the fuck you talking about. You people. I mean, people talking about tapes and all this type of shit. I'm like, sitting here like, please shut the fuck up. Please don't confuse the community even more. These people, fuck having a law degree. Fuck having a regular degree. You don't even have a diploma in most cases. Like, what the fuck is going on? And I don't mean that just because you don't have one, you don't understand, because we all know that ain't true. But when you try to come out here and try to talk fuck with my credibility, whatever, you better have something in the line, in the way of some kind of education, or it's gonna be over for you. Quick. Fucking with me. I don't mind goddamn fucking destroying you, especially when I don't fucking like you. Your ass on. I'm trying to look for the call, y'all. Not the call, but the oral argument. Is this it? All right, now let me put the topic in the chat. And I want y'all to keep in mind, please keep in mind, that at the appellate level, unless his attorney is arguing his actual innocence, 9 out of 10 times, his innocence will not be discussed. Okay? This case is over. This is a review. This is a review of potential errors that could have occurred at the lower court. We're not talking about his innocence. Talking about his guilt. We're talking about what she submitted in her brief. Okay, I told you that long before this appeal came into play, right? What did she put in her brief? What did she argue? She didn't argue anything about no daddy, no Jane Doe's, no Aaliyah, no Tate, none of that. Well, to keep the daddy out of this one, because that would be the New York. But anyway, it'd be the more of the same. Talking about errors that could have happened in the process of the trial at the lower court. She submits the brief. She does an oral argument in hopes for getting a standard of review applied. The one that she is going after is called de novo, means review it as if it was new. Meaning the justices will look at the case and decide based on what they had, how would they have made certain rulings? How would they, it's just taking a look at the case with fresh eyes. Would they would have come to the same conclusions as the trial judge did? As could they make a reasonable assessment based on what's before them on the case? Things of that nature. Okay, but paying attention to the objections that Jennifer Bonjean has raised. Okay. Oh God, it's so much. So one thing that stuck out. I hope I don't have to replay these other people's shit and then also break that down too, because I'm not doing that. I can't even go there. But you, again, I have explained to you that sometimes with regards to it could be the same situation. Sometimes the answer would be yes, sometimes the answer would be no. For an example, the appeals court does not um, accept evidence in order to determine if an appeal should be granted, right? However, in some cases, that's not the case. So if there is evidence that wasn't known at the time that the trial was going on, then yes, they will accept that evidence. Okay? Then you can submit that evidence during at the appellate phase, meaning that it wasn't discoverable. And this is what I mean. So before y'all, so let me travel to New York real quick because I already broke this down. That wouldn't apply to the text messages because the text messages was already in existence. Okay, the text messages was already in discovery. They already knew about them. So I'm not talking about no damn text message. I'm talking about evidence that wasn't already discovered. All right. Something that you can really point to is when people take a DNA test or, I'm sorry, get DNA tested like on a T-shirt or something like that, and it may that DNA may reveal that it was somebody else that committed a crime. That's new evidence that wasn't previously known. So that's why you see a lot of people get freed after that process is completed through the appellate court. Okay, well at the appellate level. Okay, all right. What up, Levi? What's up, Miss Dorothy? Okay, so we're gonna go over this again. Here we go. All right, I don't know what the sound is. Okay, hold on for a minute. Eh. Y'all, that P. Diddy shit is cray cray. They got little pictures in there too, honey. Yes, we don't have to read that. Where is it? Okay, that's not it, because that is a album. Oh, okay. Let me go up to here. Sorry, I thought I had it. Let me go get it. I mean, I don't see how these people can submit this shit, right? I mean, can play the stuff and just lie it all up. I just don't get that. Who does? How you going? I mean, you got to be a sick individual to say that I'm gonna play the shit and tell the people that they ain't hear what they just heard. And let me tell you this: some idiot. This about these tapes. Let me tell you about these damn tapes. Okay, I wasn't the one that got into no type of argument about nobody on no tape. I went by the evidence that supported that more than likely that was R. Kelly on that tape. I don't think his attorney disputed whether or not it was him on the damn tape. Oh, I know y'all can hear it through the damn speaker. Hold on, y'all. Let me get the speaker right. God. Hold on. Let me get the speakers right. This is why y'all can hear. Okay, y'all. Let me hold on. Okay, okay. I want y'all to understand this, right? At the lower court, if I'm not mistaken, with regards to the videos with what the girl name is. Let me put the indictment. Hold on. I want to get this right. Hold on. Hold on. Cause see, there's a reason why she could say what she says at the appellate level. And I apologize. I'm all over the place right now. I'm gonna tell you that right now. I got a lot on my mind. Let me pull up the indictment. Hold on. Illinois. He was only acquitted of the I tell you my mind on this shit tonight, but I still got to do it because I ain't got no other day to do it. He was acquitted on the obstruction charges, right? Okay. His count one. Count one deals with tapes. So tape or visual images that allegedly depicts a minor. Okay. All right. Hold on. Give me a minute. I'm getting the game. Give me a minute. Hey, Danny. All right. I got to get in the game. Come on. I got to get in the game now. All right. Okay. Now, the reason why, and here's something that I saw that kept being done when people were allegedly breaking this stuff down, lying about these or I don't know. At this point, I don't know what to call it anymore. But I'm just gonna have to I don't know. I don't know what to tell y'all. Because for some reason y'all come right back over here and ask me to explain what the hell they are talking about. Here's right. These people don't have a lot of credibility. All right. And that's just based on the shit they done said out their mouth, the shit that has not materialized, and that it's not a secret that a lot of these people are big lights from where it can range, from medium size to big lights. Okay. So go with that. But so let me explain something to you, okay? At any stage in this login, when it comes to submitting your argument, either whether it be written or verbally, you're always trying to persuade. You're always trying to persuade the trier of fact, right? That's going to be the judge, the jury, justice, right? I told you she is going for a standard of review, which will allow the justices to review this case as if it had never been reviewed, it had never been tried before. is the best way I can express it to you. Okay. So she's making her arguments as if, in a sense, as if and she had not made an argument at the lower court. Okay. So it is her position that the tapes does not contain child pornography. Whether it's true or not, that has already been decided by the lower court. So she can come in here and make some allegations that is different from what occurred at the lower court. At the lower court, apparently they found that it was child pornography and whatever else they convicted him of, acquitting him on the obstruction charges. Okay. So you have people that, and this is happening quite a bit. They would say when J-Bo or whoever his attorneys, whenever, comes out and say something that represents the truth. Well, that does not represent the truth no more than what the state or what the Fed put out represents the truth. Okay? There are both sides charged with making a persuasive argument. Okay? If that makes any sense to anybody. But I saw a lot of people saying, yeah, Jennifer Bonji said there wasn't no child pornography on the tape. Well, based on the transcript and based on the elements of the indictment and based on the fact that a conviction was secured in the areas where tapes involving alleged minors were involved, he was indicted. That's all I'm saying. I'm not going into whether nobody's innocent or guilty. That's neither here nor there. At the lower court, it was all about what you can prove. At the appellate court going forward, it's all about was there any errors that were committed. Okay? So you need to understand that. She's going to argue it's going to be contrary or contradictory to what the actual outcome was in some areas. She's supposed to do that. Because right now it's not about his innocence or guilt. It's about if any errors occur. It's about getting an appropriate standard of review applied to his particular appeal so that it can be successful, right? The more deference that the appellate court believes that a particular objection should receive, whether it be just say on the areas of severance, right? Severance, that is something that is discretional, right? By the lower court, by the judge. When they look at that, even though she didn't argue it on oral arguments, it was in her brief, so they'll still look at that. That is going to be given a lot of deference, meaning a lot of weight. That judge's decision is going to carry a lot of weight with the justice, with the appellate court judge. Okay. But she was smart to argue for the two in which she wants them to look at it as if a decision has never been made on it. That is in the area of the sentencing, as well as what was the other one? Because I got this from my prior breakdown. Sentencing, and what was the other area, Diva? tell you. Hold on. A statute of limitations. Okay. Okay. So now, I believe I got audio now, and yeah. Oh, happy birthday, Diva. Okay. So let me play this foolishness. I mean, this is not foolishness. What's in my head is when I just clicked on and saw the images of that Puff Daddy shit. That's the foolishness. Let me play this oral art. When y'all, I can't wait to get. I should have did that first. 'Cause I'm really geeked up because this is like my 12th time going over this, and at this point, this part is foolish. I have to come back and redo this. Like I don't get it. Let me know if y'all can hear it. Okay, y'all can see it. Y'all still can't hear it. Hold on. And listen. Okay. The that that sovereign citizen, strong man, natural, all that shit, whatever those arguments and that commentary has no place in the law, and it has no place definitely upon appeal. Okay, that is that's not even a actual area of law. Okay, so it shouldn't be conflated nowhere in what we're talking about. It makes no sense. It's not a proper legal argument. It only makes sense. It's not even recognized. It's only recognized by idiots who you try to deploy it normally to get around child support and other civil, things. I try not to play taxes and all that kind of old crazy shit. I'm got time for that. Hold on. Okay, I think I got it now.
Good morning, everyone. Welcome. Our first case for argument this morning is United States against Kelly. Thank you and good morning, Your Honors. May it please the court, my name is Jennifer Bonjean and I represent Robert Kelly. I am going to work backwards this morning and start by addressing the sentencing issue, but happy to take questions on any of the issues before the court. Mr. Kelly was indicted in a 13-count indictment. He was convicted of 6 counts. He was acquitted of 7 of those counts, including obstruction of justice based on a 2008 state court prosecution, conspiracy to receive child pornography, and then the receipt counts.
Okay, because I'm kind of remembering the questions I was asked and trying to remember all this incorrect ass commentary that was put out with regards to this oral arguments. Okay, you can use previously used evidence from prior cases. You can use it, except in areas where it is has been, you know, deemed inadmissible for the instant case, for the current case. Other than that, you can use it. So in old tape, old images, what have you, you can use it from prior cases. Old images, old tapes, old evidence that's relevant, reliable, and relatable in an instant case can be still used. Okay? They do not have to have the actual tape. What needs to be consistent is that they have the actual what was on those tapes, okay? The actual activities on the tapes. They know that the tapes allegedly went in mass production or online or what have you. It doesn't matter if it started off in a VHS form and it got moved to a DVD. That's not what they're disputing. Okay. Now, sometimes, well, not sometimes, a lot of times, a defense team will build a defense based on manipulating of that evidence because it was moved it was transferred to a DVD or whatever. But that argument usually falls flat if it has anything to do with images, if the content on there is what's in dispute, okay? Meaning like if it's minors or whatever, okay? That's what the actual issue is. And even at that, you can still build a defense with regards to it, okay? Um, I'm not sure why the chain of custody came up. I'm not even sure why that, because the chain of custody starts when it is in the possession of, well, it can be authenticated in several different ways depending on what the what the state says, okay? All right. If they says it if it originated if it originated at somebody's house or whatever, then if the state wants to submit that as part of their case and they want to authenticate the tapes or what have you, they can do so. That's digital evidence, and that's in a whole nother area of trial proceedings, and that is not my forte, but I just know how it's done. Okay. Chain of custody normally starts from the time um the investigators take possession of it. All right. That's chain of custody. Authentication begins normally, it can start there, but it also starts at some, at the person's house. Like they want to authenticate who was on there, who made the tape, how many hands it transferred to and from, things of that nature. Okay. That's a whole nother type of investigation. All right. So chain of custody isn't a real issue here. I don't remember a lot being made about the chain of custody by the defense. And again, I tell you guys, pay attention to what his attorney, the arguments they make. Pay attention to the outcome. And it will tell you, what's what. Because all the times, it's not going to be somebody out here to break this down or what have you. Somehow, for some reason, I cannot get, I don't know how, and shout out to Sylvia, right? She's back. Hopefully, she will bring those attorneys back to this section. Maybe they can answer some of these questions like that are trial attorneys and appellate appeals attorneys and things of that nature, right? So they can express what I'm saying to you in a different way. Maybe that y'all can understand it in a different way. You know what I'm saying? I'm always down for that. They need to catch some of these headaches. Yeah. But yeah, so hey Regina, hey my friend. Yeah. Oh, it's good catch, Diva. So yeah. So check this out right here. We haven't gotten there yet, but when we get there, we can talk about the burden, the burden as far as what the judge could use to justify his sentence, right? To get the enhancement on his sentence. The burden is different from when you're finding somebody guilty. The guilty is beyond a reasonable doubt. The burden for getting an enhancement when it comes to sentencing is by preponderance of the evidence, right? Yeah. But they also, that evidence he uses has to still be relevant, relatable, and reliable. Okay. But we haven't gotten there yet.
Mr. Kelly was sentenced to a 240-month sentence, statutory maximum, and that sentence significantly above the guideline range. And the district court judge properly calculated the guidelines. Maybe essentially a slight nod for them and decided, I think 20 years is the right sentence. And the district court's justification for the above guidelines range, sufficient factual basis. That's our position. Generally speaking, he relied on witted conduct, and he relied on the guidelines today would punish this more severely. Therefore, we should give him an above guidelines range. Now, I want to first start with the acquitted conduct. If you look at the district court's comments, he both imprecisely and inaccurately stated that the evidence presented at Kelly's trial essentially showed that he engaged in some type of obstructive behavior. This much.
Okay. I also heard this on review of some other people's stuff, right? The judge can consider acquitted conduct. He can either consider it or not. It's not against the law. Okay? Just because a person wasn't found guilty for that conduct does not mean that there wasn't evidence that could have found him guilty of that. All right? So the judge can consider that acquitted conduct when making a determination on his sentence.
Know though that the district court actually relied on that because the district court said I could find by a preponderance that he obstructed justice. There was no specific finding that he did. Yes, and that's an excellent point, Your Honor. Our position is the judge was imprecise. He vaguely referenced I could do this. It could be based on. But you want us to infer from that he actually did. Well, and what's the basis to do that given the judge's specific comments? Well, I think what I would like the court to do is first find that his comments were too vague and ambiguous for us to find that what he relied on. And I think in our briefs, we said it was both procedurally improper. And then we argued that even if you accept the government's position that there was this basis, the judge did make this finding. And the comments were sort of a little bit of a stream of consciousness, if you will. And he said, I could do it. So our position, as our briefs, I think, set forth, is that it wasn't precise enough. He didn't identify the factual basis. But even if we looked at those factors, they would not provide a basis for an above guidelines range. The district court sentencing seemed very grounded in the 3553 factors and his concern for the seriousness of this offense and your client's history and characteristics, which is exactly what the courts must do, is look at the 3553 factors. How do you get around that? Well, I think you still have to look at the guidelines range as a starting point. And I remind the court that probation found that there was no basis to sentence him above the guidelines. And that's not determinative. The court has to look at 3553, which again, the court spent quite a bit of time on those factors, in particular
the seriousness of the offense, the need for deterrence here, protecting the public. And those were all appropriate factors to look at. But
And 3553 is just the sentencing guidelines, and it covers all that they just went over. Okay, what a sentence should reflect. Okay, an appropriate sentence, and they have those guidelines. So someone isn't punished more severely than necessary, that they're punished, right around uh, the same way like someone else that have been, charged with the same particular conduct, and to make sure that it's not, too less of a light of a sentence. Okay, so
when a court decides to go 72 months above a guideline range, it still should identify factually specific aggravating factors that would justify it, not simply say there was this acquitted conduct that they could find. And again, our position is the government did not prove the acquitted conduct by a preponderance of the evidence. We know that because the jury acquitted him of the conspiracy to receive child pornography. So this wild goose chase that the judge referenced as sort of a basis for this above guideline range is not borne out at all. In fact, the jury affirmatively rejected the government's narrative. Different for me. I understand, but it's not logical. We sometimes see cases where maybe the government just didn't meet its burden, right?
okay, so you heard where the justice say different burden of proof, and again, these are these areas where I said, they're not particularly speaking to people that's outside the law. In actuality, they speaking to people, the people that's inside. They're, the attorneys there or whatever law professionals that's inside in there working on that case, right? So what that means is that a different burden of proof, not the typical burden of proof, as I explained, that's used when convicting someone. When sentencing someone, it only needs to be done by the preponderance of the evidence. But that evidence for those enhancements still needs to be relevant, reliable, and relatable to sentencing, okay? To justify those enhancements, okay?
We can't assume that the jury would have not found it by the lower standard. But in this case, we can tell very clearly that they did not find that those tapes that were the subject of the wild goose chase were child pornography. If they had, they would have at least convicted Mr. Kelly of the conspiracy count. It's the same child pornography. They looked at the images on that related to counts 2 and 3. They found it to be child pornography. And then they acquitted him of the conspiracy. Ms. Bunchy, if we agree with you.
Okay, so hold on. Let me back up.
Just didn't meet its burden, right? We can't assume that the jury would have not found it by the lower standard. But in this case, we can tell very clearly that they did not find that those tapes that were the subject of the wild goose chase were child pornography. If they had, they would have at least convicted Mr. Kelly of the conspiracy count. It's the same.
Okay, that is her speculation. Okay. All right. To my knowledge, the jury wasn't questioned on that. I mean, after they made their decision. Okay. So that's when I tell you that she is. So, but we already know that was not the case because they convicted him in the areas where it says child, whatever. Okay, they want you to use the abbreviations or whatever. Where there were visuals of minors, they convicted him on that conduct. So we know that was incorrect. But she could say that because this is meant to persuade. Doesn't mean that she has to substantiate her fact, what she believes are the facts in court. And as you notice, if I'm not mistaken, the other side doesn't even challenge her on that when she says, because everybody has the understanding that this is meant to be persuasive. That's it.
child pornography. They looked at the images on related to counts 2 and 3. They found it to be child pornography, and then they acquitted them of the conspiracy. Ms. Bungie, if we agree with you and send this back for sentencing, does your client realize he could end up worse off? Because the court did go above the guidelines, but very significantly, only 1 year is consecutive to the sentence that your client received in New York. So theoretically, if it's remanded for resentencing because of an error, and the court gives a guideline sentence, which is what you seem to be arguing the court should have given, that entire guideline sentence could be consecutive or half of it for more than a year, which would put your client in a worse position. So does your client realize that? Yes, Judge. I do think that if the net result was a more significant sentence, it would be retaliatory for exercising his right to appeal. So I don't think the judge.
Okay. So as I expressed before, I believe that at that moment that the justice seemed like he would consider, they would consider that, hey, all right, maybe J-Bo has a point. That based on, and when I read, remember when I read exactly what Jennifer Bonjean was speaking on, that it was vague. It was vague in the transcript. I read what the judge said. It was vague. It didn't really express why he gave a 72-month enhancement. It didn't really express that. And here's the catch, right? When you enhance a sentence, remember there's a little model I showed y'all. How you go in there, you click here and whatever, it takes the sentence up if these factors apply, or if you remove it, it takes it down, or what have you, right? It shows you how it decreases, whatever. On that model, it is very detailed as to why you're getting enhancements, why a person's getting enhancements, and why they're not. Okay? So, in order for you to be able to enhance someone's sentence, you can't just enhance someone's sentence just because you feel like it should be enhanced and not give it don't have to be a thesis as to why you did it, but it should, the judge should include some detail as to why you did it. And I'm thinking in this moment, I'm pretty sure the justice had already, read what happened or what have you, read the transcripts and all of that, because they got the brief ahead of time. And they probably saw where it was vague. But they also want to be sure in the same moment that as per the Mr. Kelly's due process, that he understands what exactly is going on every step of the way. Do he know that he runs the risk of, hey, if it goes back, if they say hey, do a retrial, he may get more time, or if they say adjust this sentence and just leave it open, that the judge, that the lower court can, give him more time. Jennifer Bonjean is already jumping ahead of it and letting you know if he does that, then she's already going to challenge that by saying it's retaliatory of just because he submitted he objected to his sentence at the lower court. Y'all, I do apologize for my voice and my choppiness. But let's continue.
Or next week it'll be the judge.
That would certainly could. If it's sent back for resentencing, the judge can start over and look at so to say it would be retaliatory. There's no grounds for that. There's no case law that would support giving a higher sentence or a sentence that would have a more significant consequence.
Well, I think the second point is a more I think a valid point to some degree, but I do think there's plenty of case law that says you can't punish someone for exercising the right to appeal, right? So if the judge were to give a net greater sentence, our position would be that that was retributive.
I just want to make sure your client understands that if he wins on this particular point, he has risks. If that he might get a higher consecutive sentence.
Yes, Judge, and frankly, to be frank, kind of all depends on what happens in the Eastern District because
That's on appeal.
that's his life sentence, right there. Essentially, it's a 30-year sentence. So, not to say this doesn't matter, but if that sentence sticks, he probably will die in prison, and that is the reality. So, we have had these conversations with the court. Is asking that, and we understand that. We had those conversations before we even went to trial, and he understands all of that. I would argue, and just moving on to again the general proposition that the general proposition that modern guidelines can just provide a basis for giving an above guideline sentence does run afoul of the ex post facto clause, where the district court is not pointing to some specific aggravating factor. For example,
Would we have to overrule Co to find for you where we?
Let me take that back a minute.
argue, and just moving on to again the general proposition that the general proposition that modern guidelines can just provide a basis for giving an above guideline sentence does run afoul of the ex post facto clause, where the district court is not pointing to some specific aggravating factor. For example,
Would we have to overrule Co to find for you where we said it's okay to look to guideline amendments to justify variance?
Okay, so, and that just goes to what I just said, right? And when it came to the area of being vague, you can't just give someone an above guideline sentence and not say why they're getting that enhancement, okay? You just can't. You can't do so. And so he should have expressed that in his opinion, right, when he made that judgment.
no, not at all. I think the court should rely on it. It's okay to look at amendments. It's perfectly okay to look at an amendment. Happens here. So, for instance, if the applicable guidelines didn't take into account, this is not the case, but for instance, the age of the victim, and modern guidelines do take account the age of the victim, then it would be appropriate under code to say, I'm going to rely on the age of the victim as a basis for going above the guidelines. But here, what we have is sort of this general idea that modern guidelines are more harsh. We care more about child pornography now, and modern guidelines are more serious or punish the conduct more severely. This is just an end run around the ex post facto prohibition. So if the court could have gotten there, but there needed to be some precise basis, and neither the court, the government, or probation, really anyone has identified a specific aggravating factor that was not addressed in the applicable guidelines. And that is the reason that this is just a Pew violation rather than a proper basis for going above the guidelines. I have about 1 minute left. I want to briefly touch on the statute of limitations issue, which I think the court is probably well versed in. But the point I want to make is that the government seems to think that so long as retroactive application doesn't violate the ex post facto clause, it's good, no problem.
Okay. So, and she keeps referencing the ex post factos where, with regards to the sentencing, is because ex post factos has a lot of variables, in it, right? Sometimes, sometimes it it makes previously behavior that was innocent back in the day, it criminalizes it now, and then it also does the reverse. Okay. Also, it does the same type of thing when it comes to a sentence. It could increase a sentence that was, if just say the sentence that you probably got 2 years, 15 years ago, you can get 10 years today, and vice versa. Jennifer Bonjean is saying the way the judge looked at it, applied a vague, well, not vague. Well, she made a vague argument, but she has, you know how she do it. She'll take one issue and pose three different problems with that particular issue. So her other problem is that it was a violation of ex post facto as well. One, it was vague. Two, it violated ex post facto. Okay, the sentencing part. So this is her argument, and with ex post facto, it shouldn't function that way. When it functions that way, I'll tell you this about when it calls as a punishment to function where Mr. Kelly is getting more time than he should have, whatever, then she's saying that that is a violation of the ex post factos, because that's not what the ex post factos was meant to do. Although ex post facto can be confusing in certain areas. Okay. And if I'm not mistaken, she has a third, a third argument. This woman is really good. Okay. I can hardly keep up with her ass. And this is my fourth or fifth time going over it, and I'm still discovering shit. I'm about to back it up a little bit. So let me back it up a minute. Because I want to make sure I explain this to y'all right.
For instance, if the applicable guidelines didn't take into account, not the case, but for instance, the age of the victim, and modern guidelines do take account the age of the victim, then it would be appropriate under code to say, I'm going to rely on the age of the victim as a basis for going above the guidelines. But here, what we have is sort of this general idea that modern guidelines are more harsh. We care more about child pornography now, and modern guidelines are more serious or punish the conduct more severely. This is just an end run around the ex post facto prohibition. So if the court could have gotten there, but there needed to be some precise basis, and neither the court, the government, or probation, really anyone, has identified a specific aggravating factor that was not addressed in the applicable guidelines. And that is the reason that this is just a Pew violation rather than a proper basis for going above the guidelines. I have about 1 minute left. I want to briefly touch on the statute of limitations issue, which I think the court is probably well versed in. But the point I want to make is that the government seems to think that so long as retroactive application doesn't violate the ex post facto clause, it's good, no problem.
And you're not arguing otherwise.
I'm not arguing otherwise. What I'm saying is that we still have to start with looking at what Congress intended. And that first starts with the language that's used by Congress in the statute itself, the best indicator of Congress's intent. And then you can also look at the legislative history. And our position is not only did statute use language like would and shall, which we know is future type of language, but it contains no language about retroactivity. And in fact, there was language, a prior version of the bill did include language of retroactivity that was excised in the final bill. So I think we could see that Congress intended this to apply prospective. I see that my time is up. I can address any further arguments on rebuttal. Thank you.
And pretty much what she's saying is that she has an issue with that what was that 32, I think 32A3. Remember it was they first had an age limit and they removed it altogether. She's saying the language in that law is meant to be for future use, not going back. So they're saying she's saying that because they removed that age limit and made it for the life of the child and whatever that new language is on that upon that amended version of that bill, it violates his rights, right? It violates that statute of limitation. Okay. Now, is that accurate? Probably not. Let me tell you why. Because this is what she's doing. She is wanting that bench of justice to do more of a inference, right? To interpret, not actually go by the language and the actual procedure. Because this is how this works, right? You can apply ex post facto to a law before that law runs out. You could make the amended changes, that's fine. You just can't apply ex post facto to new laws, whether it be state or federal, meaning that when that law goes into force, it's going to apply retroactively. Okay. She is saying she wants that bench of judges to make a determination based on the language that was used. That's why she used the words would and shall, because would and shall applies prospective, right, in the future. She wants them to determine what Congress intended, not what was actually written, so to speak, right? I think the language is pretty much clear, but we know our good friend Jennifer Bonjean likes to put pressure. I told you she likes to put pressure on someone to make a decision, right? Whether it be the jury, whether it be the judge, or now the justice. She is saying, hey, fine, read statutory law. Okay, but I'm gonna need you to create common law. All right? Meaning I'm gonna need you to what? To interpret, to decipher, to I don't want to say rearrange, but make a determination of what Congress meant. I think it's pretty clear, but that's her making a fight for her client. And again, this is meant to persuade, right? I'm still trying to look for something, y'all. So I apologize if I'm all over the place. Before you get out, does anybody have that indictment to that new rapper? Not new rapper, but this rapper called Cash Out. I've never heard of him, and I cannot find it. So, but I'm still trying to look for him. But his name is Cash Out, and he has an indictment. It's in Georgia, and it's at the Fulton County Superior Court. Because I want to cover that.
Good morning. May it please the court, Brian Williamson on behalf of the United States. The district court did not procedurally err and did not abuse its discretion with regards to the substantive reasonableness of defendants' 240-month above guidelines sentence. The district court started with defendants' proposed guidelines range, and then went above those guidelines upon a thorough explanation of the 3553A factors. As such, the primary basis for the above guideline sentence was the court's finding that the offense conduct was horrible, horrific, and deserving of very, very serious consequences for Mr. Kelly. I think the court has already picked up on that. Defense counsel loses the forest for the trees a little bit in arguing that the above guideline sentence was based solely and exclusively on the obstructive conduct. And
is it your view, Mr. Williamson, that the court did rely on the obstruction of justice conduct in imposing sentence?
So I think it's important to clarify that the starting point was adopting defendant's guidelines. And
but
then
a basis to vary.
I think it was a data point in justifying the above guideline sentence. It was not, neither were imposed specifically as a mechanical basis to vary.
And can you distinguish for me between what you mean by a data point and a basis to vary?
Right, right. So
Did the court consider it? It's hard to tell from the court's comment that it could consider, and I'm not sure there's any specific finding by a preponderance of the evidence as to why the obstruction of justice conduct occurred, or that the government did prove it by a preponderance of the evidence.
Yes, Your Honor. So, the sentencing court found by a preponderance of evidence that obstructive conduct occurred. Now, whether that comprised a specific part of the above guideline sentence, or whether that was a further justification aligned with the seriousness of the offense conduct, the sentencing transcript does leave that ambiguous. But it's clear that on the offense conduct alone, the 3553A factor alone, and the seriousness of the conduct, the court could have arrived at 241 sentence by December. So
just to pin this down with clarity, your position is that Judge Light and Weber made the findings necessary to consider the obstructive conduct.
yes, Your Honor.
Okay. So this is just my opinion. Okay. He knows that for enhancement, that it can't be vague. Okay. Now, because I told you, I read it, and when I read it, and when she made that argument, I felt like it was vague. Apparently, he felt like it was vague. But you see what he came back, he tried to, support the judge decisions. He's saying that based on R. Kelly's the sentence and the conduct and so on and so forth, that the judge could have still made that determination to give that above guideline sentence, right? So what you have to look at, you have to see, okay, on that little model that I showed you, that little tool, like where you check this box and see, okay, should he get this extra time, whatever. Just let me give you an example, okay? You can, if the model starts off with what you get for a particular crime or whatever, just say you get 5 years, right? But if that crime says, hey, that the defendant was in a position of authority, and then, and then you check that box, you can get extra months, okay? Without explaining that. So where being vague would be okay. All right, because there's a box there that says, hey, if that person was in authority, a lot of that, you see a lot of that when they go to sentence, if they sentence those Catholic priests and stuff like that, Boy Scout leaders and stuff like that, teachers and people like that, you'll say, hey, that person was in authority. All right, you just simply check that on that little tool I showed you that you use for sentencing. And then that person get that enhancement, and that you don't really have to explain that, because that was already proven pretty much should have been proven in the elements and throughout the facts submitted in the case. So I'm pretty sure that is what Mr. Bryan means. But let's back it up a little bit.
And the seriousness of the conduct, the court could have arrived at 240 months without guideline sentence by itself. So,
But just to pin this down with clarity, your position is that Justice Butler made the findings necessary to consider the obstruction.
yes, Aaron. So, as to the obstructive conduct, per this court's precedent, it is not in dispute that a district court may consider acquitted conduct as long as it's proven by conduct. That's exactly what the district court did here. Moreover, it's clear what the sentencing court was referring to. The Keystone Cop kind of operation in which these tapes spread throughout the country. And Kelly's been spent hundreds of thousands of dollars in effort trying to get them back. This is not just about the receipt of the tapes. This is about a broader sense of obstructive conduct. If you read the sentencing transcript in full, it is quite clear that as the government reviewed, there was a broader set of obstructive conduct that was in the court's mind with those comments. That included conversations that Kelly, the defendant, and his associates had with Jane's parents during the course of the investigation. The result of those comments, including Jane's family's non-participation in the grand jury and subsequent 2008 state trial, payments made to Jane's father during that time period, and others.
Okay, so right there, what he is saying, what he is demonstrating right there, that there was other conduct that could be considered as obstruction. Okay, although he was acquitted of the obstruction charges, again, as I told you before we started, that you can consider acquitted conduct during sentencing. So he pretty much said that, as well as he gave an illustration of other obstructive behavior that the judge could consider when making a determination on the sentence, right? So even though Von Jean was saying their client was acquitted of the obstruction charge, and somehow some kind of clever way she wrote in the tapes with that, my mind, of course, isn't on this really wholeheartedly, and I just have to admit that to you. But she, you saw how she did it, and I'm not going to go back and play it again. But he is saying, regardless of any of that and all in what she's saying, the judge still could have arrived to the sentence he came up with, even though his explanation was vague. The enhancements were justified by the conduct that was alleged, throughout the trial, right?
Burden on the sentencing court to justify the public sentence is not high, and it was more than met here by the court's consideration.
Okay. You heard what he said. He said the burden on the court wasn't high to justify above a guidance sentence, right? So that tells you that they have to. You can't be vague when giving somebody an above guideline sentence. Now, this is going to be interesting in this little area. And I believe this is probably why that lady, that justice, kind of stayed there, because, it probably is a little toss up in their minds. They're going to have to look at that a lot closer. What is the burden? And did that judge meet that burden? So that's going to be, I don't know.
Moreover, it's also not to dispute that there was no ex post facto finding. The court's reference to the evolution of sentencing guidelines on sex offenses. Defendant concedes as much in his papers. Your Honor, you mentioned the Coe case, and that's exactly on point. It actually encourages reference to amendments to the guidelines without reading into the limitations that defense reads into it, that those should be used by later sentencing courts in considering whether their sentences meet what Congress was intending. So at end, the sentencing court based its 240-month above guideline sentence primarily on defendant's horrific offense conduct, not in particular on either his obstruction of justice or the abolition of the guidelines. The sentence was thus procedural and substantively sound. Turning to the statute of limitations question, defendant's indictment for sexual exploitation and inducement of children was timely brought. The statute of limitations period as to defendant's victims never expired, and at the time of the offense conduct, prosecutions were viable until the victims turned 25. But before Jane, Nia, or Pauline reached the age of 25, Congress in 2003 expanded the statute of limitations period to the life of the child. This was unambiguous. Section 3283 states that no statute of limitations that would otherwise preclude prosecution for an offense involving sexual exploitation of a child shall preclude such prosecution during the life of the child. This is a universal approach to changing the statute of limitations. It's forward-leaning and it's backward-leaning. There is and can be no ex post facto violation when an otherwise viable statute of limitations, such as we have here, is expanded. Multiple courts of appeal agree on that front. And while this court has yet to have occasion to review that specific question with regards to that specific statute, 18 U.S.C. 3283, it has nonetheless agreed with the principle that no constitutional violation occurs in these circumstances. That's the United States versus Gibson case, relying on Supreme Court precedent in Statute. The application of 18 U.S.C. 3283 should thus not be considered impermissibly retroactive. It is not reviving a previously moribund limitations period. Instead, it is explicitly precluding the application of prior limitations periods that were anything less than for the life of the child. The indictment.
Are you saying that the land grab analysis doesn't matter given Gibson?
I wouldn't
It
set
seems
aside.
like it's a separate issue. The Gibson is the ex post facto argument, and defendant has conceded that's not what he's pursuing on appeal. Instead, he's arguing statutory construction, that if you look at Congress's intent and look at the framework under land grab, that Congress's intent was not to make this retroactive, which is a separate issue.
Your Honor.
Right. So you see how that justice recognized that it's a separate issue, meaning, so that's confirming what I said with Bonjean. Although, and this is when I broke it down when we were reading her brief, right? How she would make one objection, right? Raise one issue, but yet have a couple different problems with it and have supporting arguments for those different problems. I like to look at it like a leaf on a tree, right? You got the tree, and then I don't know why I'm using this goddamn analogy because I don't know nothing about no damn agriculture. So let me see. Like farms, right? Like you have put it like, like it's a 3-in-1 type deal. All right. 3-in-1. See, I can go to a shopping reference and get it right. Like a 3-in-1. She raised one issue, but she has 3 doors, right? Okay. So just say she increases her chances that maybe they will decide in her favor, right? I'm not saying that they will, but I'm just saying she increases the chance. And that's what you want to do. She is very good. She is very good with this shit. I'm telling you. and she finds actual legal argument.
I think the language of the statute speaks unambiguously, and we don't even have to get to what Congress, the underlying intent of Congress was. It's hard to read 3283 in a manner that doesn't apply both backwards and forwards. If we do apply language, it satisfies both the first step and the second step.
Defendants spent a lot of time in the brief focusing on the Tusi case and the statements that statute of limitations should be liberally interpreted in favor of opposed in criminal cases in particular. Can you respond to that argument?
Yes, Your Honor, absolutely. So the Tusi case and its progeny, that's a fine statement of what Tusi stands for, but there's always a carve-out for when Congress explicitly provides for it. So it's the government's position that that's exactly what 18 U.S.C. 3283 does.
What if we get to step 2 of land grab? How would Tusi impact that analysis?
So, in a sense, defense is asking for an exception that doesn't exist. Reading repose into the second step of Tusi, in defense's brief, they set out that this creates a broader set of rights and obligations in that provided specifically in the second step of land grab. I wouldn't say we need to reach the second step of land grab because step 1 is satisfied given the unambiguous nature of the statute. And
But if
step
we
2,
do,
as to step 2, if there is no retroactivity problem, we're not even in step 2 of land grab. And I'm not sure they've pointed to a case that says that the repose considerations in 2C supersede the satisfaction of step 1 and 2. So if the court doesn't have any further questions. Thank you.
Thank you. Picking up where my colleague left off, our position, of course, is that it is not okay to just jump to the ex post facto problem. And we disagree on the language of the statute and what it suggests. We have express language from the bill version that demonstrates a desire to include a retroactivity provision that was then removed. Now, retroactivity doesn't mean an ex post facto violation. Retroactivity could be an ex post facto violation, but it doesn't mean an ex post facto violation. And so we are in this category where we acknowledge that the government, that this was not, again, a situation where the statute of limitations has expired, but it was still retroactive. And there are still considerations that this court considered, and that the United States Supreme Court has set this starting place. And in Landgraf, the court said the default position is prospectivity. So we shouldn't start with a retroactivity unless otherwise. 2C says criminal statute should be interpreted in favor of repose. So those general principles, those canons, need to be the starting point. And I think lower courts, to some degree, have gone wayward from that. I think the U.S. Supreme Court might get us back on track with that. And I know,
but if the language is clear at step 1, that doesn't come into play.
Well, the language,
I understand you don't think it's clear,
but I think it's clear in the other direction. But
if it is not clear in the direction you want it to be, then we don't get into the 2C land.
Well, our position is that the legislative history, we also agree that you don't need to get to step 2. So we're in agreement on that. But, and obviously we would acknowledge that some circuits have already sided with the government's position on this issues in front of the Second Circuit presently. So
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But perhaps it will be split at some point. But our position is that the U.S. Supreme Court would see this differently in light of those general principles, and that we need to start there. And I think the court is well equipped with the information that we've provided and the government's provided to make that decision. I want to get back to this obstructive conduct very quickly. I'm still unclear. I think the government is unclear. Everyone is unclear on how the court reached the above guidelines sentence. And I don't think it's sufficient to just say, Well, he spent a lot of time talking or speaking about the 3553 factors, and therefore it's all just. I think that's dangerous, and I think the court needed to be a little more precise with its factual basis. And notably, the government is focusing this court more on a different set of obstructive conduct, for which Mr. Kelly was also acquitted, that the district court didn't even mention. The government talks about the intimidating behavior, the hush money towards Jane Doe and her family. And in our reply brief, we honed in and demonstrated for the court that is not what the evidence showed. Jane Doe said nothing of the sort. She said there was no hush money. The mother unequivocally said there was no hush money to testify falsely in front of the grand jury. Nothing of the sort happened. They had their own reasons for wanting to not cooperate with the investigation, and it wasn't as a result of Mr. Kelly's conduct. Now, the government, interestingly, is focusing that court in that direction, but the district court didn't mention it at all. The district court didn't rely. At no point did the district court say, I'm going to give him an above guidelines range because he engaged in obstructive conduct as it relates to his interactions with Jane Doe 1 or.
Now, just to be clear, the only reason why it sounds like she's arguing his innocence or guilt, she's not really arguing his innocence or guilt, okay, as it would apply at the lower court. She is arguing that that the court find that he did not obstruct as it relates to the issue on the table there, as far as why he got a above guideline sentence, okay? So I'm gonna make sure y'all understand that. All right. At this point, right, when you hear something that might sound like he's arguing his innocence or guilt, at any time when it's going from at this stage and going above, it's normally at this, unless he changes it to say that he is actually innocent, it's only to support her argument, not to say, hey, my client is innocent. She's saying that because they did not find him guilty of obstruction, therefore the behavior for obstruction should not have been used to calculate an above guideline sentence.
He was more focused on really what was the receipt count about this wild goose chase. And I want to end on the point that the evidence showed that those cases that were the subject of wild goose chase, which were pled and charged in the indictment, did not contain child pornography, contained old-fashioned pornography, if you will. It did not contain child pornography. The government didn't prove it, which is why the jury came back as it did. And there is really no avenue for the court to find under this lower standard that it did.
Now, okay. Now, Jumbo, I don't know how to explain that, baby. But let me rewind it.
I'm going to give him an above guideline sentence because he engaged in obstructive conduct as it relates to his interactions with Jane Doe 1 or her family. He was more focused on really what was the receipt count about this wild goose chase. And I want to end on the point that evidence showed that those cases that were the subject of wild goose chase, which were pled and charged in the indictment, did not contain child pornography, contained old-fashioned pornography, if you will. It did not contain child pornography. The government didn't prove it, which is why the jury came back as it did.
Okay, I'm glad I caught it. Okay. In her opinion, hold on, let me not say that. Hold on, let me let that play some.
And there is really no avenue for the court to find under this lower standard that it did. If it did, then it's unclear why the jury would ever have acquitted any of them on the conspiracy count. So our position is the judge.
Ooh, she's good.
Got that wrong factually, if he relied on it at all, and that the sentencing justification was too nebulous and that we needed a more precise basis. But how else can Mr. Kelly defend that if he doesn't have a specific articulated basis? That, I thank your honors. Thank you.
Our thanks to all counsel. The case is taken under advisement.
Okay. I'm gonna tell you how hard this is. Okay, this it's pretty much trying to figure out what another attorney is thinking, right? So let me tell you what she said and how she gets away with what she said. She is using it is in her opinion that the government did not prove it. They know that the government apparently proved it because he was convicted. It is in her opinion that they did not prove it. I'm just trying to show you how this lawyer shit works, okay? Why I wish I just would have went and been a dentist, honey. Okay. And I dropped the link for this segment because I didn't know before we move on to the next. So y'all understand what I'm saying? Before y'all call Miss Jennifer, that ain't actually the truth now. Because all right, and she's monkeying around with the burden of proof, okay? Because the burden of proof for sentencing is by the preponderance of the evidence. Burden of proof for finding somebody guilty is by beyond a reasonable doubt. She is saying that she don't believe that the government proved that that was, obstruction or child pornography. Okay. Excuse me. All right. Does anybody understand what I'm saying? Did I lose anybody? Hey, Paul. Did I lose anybody? It is a skill. Baby, she good. She being good with this. You can tell she been doing Sorry about that. Yeah. Ooh, honey. Anybody confused? So, so you understand, y'all. You can use evidence from a prior charge, even though he was acquitted of those charges back in 2008. All right? You can use it. Okay. This is a different jurisdiction. Her and here's the thing, right? You remember there was a bunch of talk about, double jeopardy and things of that nature, whatever. She didn't raise anything about no um a legal argument about double jeopardy or anything like that. That she know it would play, okay? Because she know it was correct jurisdiction and venue. Because there's something called subject matter jurisdiction, right? That runs in the feds. Okay? Very easy to prove. What court has jurisdiction to hear the matter, and where did the crime occur, or where the person lives, or whatever determines the venue. Very, very simple. Okay? No. Okay, now I don't want nobody asking me these questions. When you get confused again, y'all ain't asking because I'm not going over this no more. Just put together what the is. I got them in my title. When I've broken this down on prior occasions, and I'm sorry, my mind ain't in it tonight, but especially on this, I want to get to this P Diddy stuff. No problem, Shawty. Thank you, Miss Cookie. I want to make sure y'all understand. Ooh, honey, y'all, this, baby, I want to get to the good stuff. This foolishness with this hemp. It is. Lord mercy, y'all. The men done came up. I'm falling it before you. Ooh, the men done came up, honey. The men. And that ain't a crime. I'm just saying. And they don't really be on the crime when they be on the down low. It just be shocking. So let me put this topic in. Also mention plus photos. Y'all now listen. Do y'all think did you play the part where she said the person was determined to be CP? Yeah, I played the whole thing. I just stopped it here and there. But I think in that clip, right? She does at one point says that it was that the court found him guilty of the child pornography, but she said it wasn't child pornography, right, Danny? Child, where is the paperwork? Mm, 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 mm. Wait till y'all see these pictures, y'all. Ooh. And now, at what point do we think that some of this stuff is become now like malicious prosecution? And even though this is a civil suit, but still, he's going to be, if he loses, he can be held liable, right? That this becomes malicious and frivolous. Because they got photos in here. Let me close some of these windows. All right, Fred. Come on up. Y'all, I was like, huh? The images, y'all, tapes 2 and 3 was CP, but they didn't find tape. I think they said, because remember, Danny, it was an issue about tape 4. Like they couldn't find it, or and here's the thing, when we was discussing that back in, way back, right? I was saying that they don't actually have to have a 4th tape. Okay? They don't actually have to have a 4th tape. Testimony that there is a 4th tape somewhere is sufficient to be evidence. Okay? But this is her oral argument. Oral arguments are meant to be persuasive. She can frame them up in a manner that, it supports what she said. Okay? Put it like that. I don't think the words loss and damage came up, DB, because it wasn't mapped. Let me run it a final time before we move on. Let me run it a final time so we can hear about these tapes, because you know sometimes people from other places will filter in, that misinformation through over here. And I don't like to have no misinformation. So I would rather take the time to go ahead and replay it again, make sure we have that understanding of what she's saying happened back with the tape. It does not mean, again, that it played out this way at the lower court. Because we do know that he was convicted of those charges at the lower court with regards to some tapes. All right? We do know that. What up, Toy? I mean, people have been chanting that there was no child pornography, like she didn't say it. Oh, okay. Let me run it again.
Good morning, everyone. Welcome. Our first case for argument this morning is United States against Kelly. Ms. Bunchy.
Thank you and good morning, Your Honors. May it please the court, my name is Jennifer Bonjean and I represent Robert Kelly. I am going to work backwards this morning and start by addressing the sentencing issue, but happy to field questions on any of the issues before the court. Mr. Kelly was indicted in a 13-count indictment. He was convicted of 6 counts. He was acquitted of 7 of those counts, including obstruction of justice based on a 2008 state court prosecution, conspiracy to receive child pornography, and then the receipt counts. Mr. Kelly was sentenced to a 240-month sentence, the statutory maximum, and a sentence significantly above the guidelines. And the district court judge properly calculated the guidelines, and gave just essentially a polite nod to them and decided that I think 20 years is the right sentence. And the district court's justification for the above guidelines range lacked sufficient factual basis. And that is our position. Generally speaking, he relied on acquitted conduct, and he relied on the guidelines today would punish this more severely. Therefore, we should give him an above guidelines range. Now, I want to first start with the acquitted conduct. If you look at the district court's comments, he both imprecisely and inaccurately stated that the evidence presented at Kelly's trial essentially showed that he engaged in some type of obstructive behavior.
Ms. Bunchy, do you know, though, that the district court actually relied on that? Because the district court said, I could find by a preponderance that he obstructed justice. There was no specific finding that he did.
Yes, and that's an excellent point, Your Honor. Our position is the judge was imprecise. He vaguely referenced, I could do this. It could be based on.
But you want us to infer from that he actually did.
Well,
and what's the basis to do that given the judge's specific comments?
Well, I think what I would like the court to do is first find that his comments were too vague and ambiguous for us to find that what he relied on. And I think in our briefs, we said it was both procedurally improper. And then we argued that even if you accept the government's position that there was this basis, the judge did make this finding. And, the comments were sort of a little bit of a stream of consciousness, if you will. And he said, I could do it. So our position, as our briefs, I think, set forth, is that it wasn't precise enough. He didn't identify the factual basis. But even if we looked at those factors, they would not provide a basis for an above guidelines range.
The district court sentencing seemed very grounded in the 3553 factors and his concern for the seriousness of this offense and your client's history and characteristics, which is exactly what the courts must do, is look at the 3553 factors. How do you get around that?
Well, I think you still have to look at the guidelines range as a starting point. And I remind the court that probation found that there was no basis to sentence him above the guidelines. And
that's not determinative. The court has to look at 3553, which again, the court spent quite a bit of time on those factors, in particular, the seriousness of the offense, the need for deterrence here, protecting the public.
And those were all appropriate factors to look at. But when a court decides to go 72 months above a guidelines range, it still should identify factually specific aggravating factors that would justify it. Not simply say there was this acquitted conduct that they could find. And again, our position is the government did not prove the acquitted conduct by a preponderance of the evidence. We know that because the jury acquitted him of the conspiracy to receive child pornography. So this wild goose chase that the judge referenced as sort of a basis for this above guidelines range is not borne out at all. In fact, the jury affirmatively rejected the government's narrative.
Different burden.
I understand, but it's not even, it's not logical. We sometimes see cases where maybe the government just didn't meet its burden, right? We can't assume that the jury would have not found it by the lower standard. But in this case, we can tell very clearly that they did not find that those tapes that were the subject of the wild goose chase were child pornography. If they had, they would have at least convicted Mr. Kelly of the conspiracy count. It's the same child pornography. They looked at the images on related to counts 2 and 3. They found it to be child pornography, and then they acquitted him of the conspiracy.
Ms. Bonji, if we agree with you and send this back for resentencing, does your client realize he could end up worse off? Because the court did go above the guidelines, but very significantly, only 1 year is consecutive to the sentence that your client received in New York. So theoretically, if it's remanded for resentencing because of an error, and the court gives a guideline sentence, which is what you seem to be arguing the court should have given, that entire guideline sentence could be consecutive or half of it or more than a year, which would put your client in a worse position. So does your client realize that?
Yes, Judge. I do think that if the net result was a more significant sentence, it would be retaliatory for exercising his right to appeal. So I don't think the judge could, or and I frankly don't think the judge
The judge
would
certainly could. If it's sent back for resentencing, the judge could start over and look at everything. So to say it would be retaliatory, there's no grounds for that. There's no case law that would support giving a higher sentence or a sentence that would have a more significant consequence.
Well, I think the second point is a more I think a valid point to some degree, but I do think there's plenty of case law that says you can't punish someone for exercising your right to an appeal, right? So if the judge were to give a net greater sentence, our position would be that that was retributive.
I just want to make sure your client understands that if he wins on this particular point, he has risks that he might get a higher consecutive sentence.
Yes, Judge, and frankly, to be frank, kind of all depends on what happens in the Eastern District, because
That's on appeal.
that's his life sentence, right there. Essentially, it's a 30-year sentence. So, not to say this doesn't matter, but if that sentence sticks, he probably will die in prison, and that is the reality. So, we have had these conversations with the court. Is asking that, and we understand that. We had those conversations before we even went to trial.
Hold up, Danny. You said I just passed it. Okay, wait a minute.
I would argue, and just moving on.
Hold up.
Again, the general verdict, right? We can't assume that the jury would have not found it by the lower standard. But in this case, we can tell very clearly that they did not find that those tapes that were the subject of the wild goose chase were child pornography. If they had, they would have at least convicted Mr. Kelly of the conspiracy count. The same count.
Okay, she said that they didn't find that those tapes that was the subject of the wild goose chase. Okay, so I'm glad I got the indictment. Hold on. Where's the indictment? You have to listen to the way she frames what she says. Okay. I'm awake now. Okay. Okay, 3. 4. Five is okay. So let's count 5. Okay, so count 5 was tape number. Um, okay, section. Video and getting yourself a minus. Okay. So video 1, video 2, video 3, and video 4. Count 5. He was acquitted on, right? There's the rest of the counts. What other damn count? Okay, count 6. It was what tape? Count 6 was the grand jury, continue around the district, June Brown, video 2, 3, and 4. Count 7 was video 2, 3, and 2 and 3. Okay. So, Jennifer Bonjean, what do you mean? Let's take it back a little bit. Great catch, Danny. Let's see what y'all saying in this chat. Okay. Ooh, y'all so good over. Your girl's knocked out.
I understand, but it's not even, it's not logical. We sometimes see cases where maybe the government just didn't meet its burden, right? We can't assume that the jury would have not found it by the lower standard. But in this case, we can tell very clearly that they did not find that those tapes that were the subject of the wild goose chase were child pornography. If they had, they would have at least convicted Mr. Kelly of the conspiracy count, the same child pornography. They looked at the images on related to counts 2 and 3. They found it to be child pornography, and then they acquitted him of the conspiracy.
Ms. Bungie, if we agree with you,
Okay.
does your client realize he could?
Listen. She pulled a fast, and even that justice didn't even catch. She said that they found him guilty on what charge? What she said? Charge 2 and 3. Hold on. On count 2 and 3. Hold on.
Not found it by the lower standard. But in this case, we can tell very clearly that they did not find that those tapes that were the subject of the wild goose chase were child pornography. If they had, they would have at least convicted Mr. Kelly of the conspiracy count, the same child pornography. They looked at the images on related to counts 2 and 3. They found it to be child pornography, and then they acquitted him of the conspiracy.
Ms. Bungie, if we agree with you,
Okay. So what she's trying to to conflate it all together, tie it all together, or in an effort to kind of misrepresent the facts a little bit, because she's trying to say, make an argument to say, hey, they did find him guilty of child pornography on counts 2 and 3, right? But then she says, like, it's preposterous that they also acquitted him with regards to those same videos, because I just went through and showed you what those other counts, that it was it was video 2, 3, and 4. Sometimes it's 2 and 3, whatever. But 2 and 3 is kind of consistent with the obstruction areas that he was acquitted of. So she is trying to make an argument that not even the jury was sure that it was child pornography. Because if they were, why didn't they convict him, straight through, right? Straight down. She's just making a pat in her argument. Because they should have pointed out, hey, well, but they know that the standard that she's trying to argue is de novo. They're gonna have to go back and look at it all over, as if they're just making the decision themselves, right? To say, hey, could they have found, with the evidence presented and the facts presented in the case, would they have ruled the same way? She's just making her challenge, her argument to it. Go on, Jennifer, girl. You girl, my girl, honey.
Does your client realize he could end up worse off? Because the court did go above the guidelines.
So we're clear. In some, she is saying that the court, I'm sorry, not the court, that the jury found it to be child pornography. So they found him guilty. She is saying it's not reasonable, or it's not sufficient, that it don't make sense that they would say, hey, it's child pornography on these counts, same tape or images in question repeats itself during the obstruction charges, but they find him in what she good. Because those obstruction charges wasn't really about hold on. Let me get this up. Where's obstruction? Let me go back to 5. 5 is more expansive. Count 5. Y'all make me work, honey. Okay, killing, kill engaging with engaging. Okay, video 1. So they had to substantiate that. See what she did? They had to substantiate under this count, 1, that they were minor, 2, the collection actions of Brown and McDavid and Kelly. Also, that their video 1, video 2, 3, and 4 depict Kelly engaged in sexual content tag and sexual acts with the minor one when minor one was under the age of 18. Now we do know that's that tape, that infamous tape. Okay. So she's trying to say is that because they found him not guilty with for these obstruction charges, she's trying to say they also found that it was no child pornography on the as it relates to those images because they were a part of the elements here. Okay, and remember, you have to find, in order to find somebody guilty, you got to find them guilty of those elements. Those tapes were a part of those elements under this count. So she can safely say, make the argument that she made. Okay? Baby, when I tell you, oh my God. Oh, baby, y'all get in trouble. Y'all need to scrape y'all money together and hire her ass. God damn. This lady, listen, right? And this isn't um let me see. I can tell how she's because you know, not everybody's very successful on appeal, you know. You would be lucky to get two or three of them to go your way in a 5-year period or whatever, if that's what you specialize in sometimes. But listen. She is actually distinguishing. She separates the video depictions under 1, 2, 3, and 4 and count 1, 2, 3, and 4, whatever he got convicted in, from the ones he was found not guilty of. Although they are the same images. But because when you indict someone, the elements, may repeat, in count after count. Okay, you could look at it as a separate and distinct fucking issue. But the same evidence and element applies here. But she just made an argument as if they don't. I'm too old. I'm too sleepy, too retired for this type of shit. Oh man, y'all, baby, and shout out to y'all for making me go through it and making me think some more. Levi, I had an incident like that maybe a week ago. We was on the phone. He had pushed me to think and to figure it out. Did y'all catch what I just said? She just made images which are the same images unrelated to each other under the same indictment in a different court. Girl, bye. Yeah. Yes, Danny, you called it. You called it. That's why I went to see 98 the same. Okay, wait a minute. What? Yes. God darn. I ain't playing. Y'all go look at the indictment. Y'all want me to, you know, I'll flash it up here real quick. I ain't making this up. I'm not making this up. You, huh? Girl, it's the same tape, girl. That's some slick shit. And listen here, and I think with the prosecution comeback, apparently they didn't catch it either. But we caught it. Count one is tape video one. Count two is video two. Count three is video three. Count four is the video four. Count five is where he starts to be he's being found not guilty, right? Count five is where material to the indictment, meaning this is important to the indictment. That's R. Kelly, he's a defendant. This is, you have to prove this time span from 91 and on until 2014, so on and so forth. Together with McDavid, Brown here. He was involved in 1997. You got to substantiate that minor one was around 12, 13 years old in 1996, 1997. This is just how you have to prove this. I'm just going real quick. Minor 2, 97, she was 17. Minor 3, 1996, she was approximately 15. Minor 4 was 16 and 99. Kelly was born in 1967. You have to substantiate that. Kelly engaged in sexual conduct with sexual contact and sexual act as those terms defined under 18 USC 2246 with minor 1, 2, 3, 4, and 5 when they were under age 18. Between and around 1998 and around 2002, Kelly recorded himself engaging in those sexual minors, minors 1, 2, 4, and 5. Video 1, 2, 3, 4 depict Kelly engaged in sexual contact and sexual acts with minor 1 when minor 1 was under the age of 18. So video 1, 2, 3, and 4 depicts minor 1. Okay? We know that is the same video because that's the same reference video. Minor 1 with video 1. Minor 1 with video 2. These are the same video that's alleged in the obstruction count. But somehow, she's just separated and made a point that, hey, because the jury did not convict him with the obstruction charges under count 5 and so on and so forth, that somehow that they didn't find that it was child pornography. Not saying that they really did find that it was child pornography under one, two. She didn't state it like that. You heard how she put this little spin on it. Says, in counts 2 and 3. Girl, girl, bye. Yes, she did. I ain't mad at her. That's how that's done. And they didn't even catch it. Prosecutor didn't even catch it. Am I right? Did the prosecution come back and say, yes, it was child pornography? Because they probably had their what they wanted to say as far as a prepared defense already in their head, because they're on the defense now. No, the taste wasn't tampered with. Right. Mm, 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 mm. Ooh. Let me get down to P next. So y'all got that. So we cleared that up about the tape. Okay, so what Jennifer Bonjean argument is, her argument is what she alleged. Again, it's meant to be persuasive, and it doesn't mean that it is actually what happened. Okay. Ooh, girl. Divas have a different conversation. Yes, honey. Now, before I get too sleepy, I just want to show y'all these images. That's P Daddy. That's the son. That's some white dude. I don't know who she is. That's a white lady. That's some businesses. I want y'all to see these images of who I think they say Stevie J. This is the shooting at the following screenshots of the aftermath of the restroom where G was shot by either Mr. Combs or J. Combs. I don't even remember nobody. Him and his son and shot somebody. Okay, this supposed to be Stevie J penetrating a Caucasian male that Mr. Combs provided to Mr. Jones. They say that's Stevie J, child. Woo! And they say Mr. Jones was sexually assaulted by Young Miami's cousin in 2022. This is civil action. Now, I have a question behind it. If this alleges rape and all of this, I don't know what's the claim about, what the claim is about. But if it alleges rape and force and all this whatever, I don't know. And something happened in 2022, that's still within the statute of limitations. Why they ain't? Let me get to reading. This dude named Rodney Jones, child. Birth is Sean Combs, Justin Dior Combs, Ethiopia, Habtemarian, Lucian Charles Grain, Christina Coran, Shalice Recording Studios, Love Records, Motown Records, Universal Music Group, Combs Global Enterprises, John and Jane Doe's 1 through 10. That usually means that they're going to be named at a later date. ABC Corporations, 8 through 10 means the same thing, right? A company named at a later date. Plaintiff Rodney Lil Rod Jones, Mr. Jones, hereby alleges as and for his complaint against defendant Sean Combs, Mr. Combs, defendant Justin Dior Combs, J. Combs, Defendant Lucian Charles Grains, Mr. Grains. Defendant, I don't name all those people. Let's see. Jurisdiction and venue. This court has personal jurisdiction over the defendants under and consistent with the constitutional requirements of due process in that the defendant, acting directly or through his agents or apparent agents, committed one or the more faults. A transaction of any business within the state, be making the making of any contract within the state, the commission of a tortious act within this district, and the ownership, use, or possession of any real estate in this state. From September 2022 to the date of this filing, defendants have consistently and purposefully availed themselves of the privilege of conducting activities within New York, thus invoking the benefit and protections of New York law. In return for these benefits and protections, defendants must submit to the burdens of litigations in New York. So that pretty much means that during this period of time, you was conducting business and breaking the law, your ass, you know, should be held liable in civil court, right? This litigation arises from or it relates to the torturous activities defendants visited upon defendants in state of New York, California, Florida, oh Lord, and United States Virgin Islands. Now they're all overseas doing the nasty. This torturous conduct violated United States federal RICO laws. What? Uh-oh. Could one be punished for Mr. Sean Puffacone? Lord, have mercy. Requiring defendants to litigate these claims in this district does not offend traditional notions of fair play and substantial justice. Plaintiff's claims arise from some conduct occurring by defendants in New York. Parties. Plaintiff Rodney Jones is an American artist and music producer. Mr. Jones resides in the state of New York and California. Defendant Sean Combs is a rapper and record executive, properly known by his stage names Puff Daddy, Puffy, P. Diddy, Brother Love, or Love. Mr. Combs came to fame in the early 1990s with his record label Bad Boy Records. He rose to prominence in the music and entertainment industry over the decades and is regularly referred to as a hip hop mogul. Mr. Combs resides at 200 South Mapleton Drive, Beverly Hills, California. That is Puff. Defendant Justin Combs is the son of Mr. Combs and Misa Hilton. Jay Combs was born on December 3rd, 1993. Jay Combs is a producer and actor. He has appeared on TV series like Catfish, the TV show Wild and Out, and Hip Hop Squares. Defendant Justin Dior Combs resides at 1550 North El Central Avenue, Los Angeles, California. Defendant Lucian Charles Grains is the CEO defendant of Universal Music Group. Ooh, okay. I don't know why this white man in here. Okay, they just pretty much. Okay. Let me get to the summary of events, child. From September 2022 to November 2023, Mr. Jones produced 9 songs on Mr. Combs' Love album. Mr. Jones lived with Mr. Combs for 9 months at a time, spending holidays, birthdays, and missing major family events. Uh-oh, so they trying to establish a relationship. Uh-oh. Uh-oh. This gonna go left. Yeah. So no wonder Young Miami is up and through this. Okay. Mr. Jones resided at Mr. Combs' a residence located in Los Angeles, California, New York, and Miami, Florida. Mr. Jones also spent several weeks on a yacht rented by Mr. Combs in the U.S. Virgin Islands. Throughout his time with Mr. Combs, Mr. Jones witnessed, experienced, and endured many things that went far beyond his role as a producer on the Love album. The claims raised in this complaint have been corroborated through witness statements, video, audio recordings, and images that Mr. Jones has in his possession, y'all. Lord, they got the evidence. We're going viral. That Mr. Combs required Mr. Jones to record him constantly. On several occasions, Mr. Combs took Mr. Jones' cell phone and began recording himself. As a result, Mr. Jones has secured hundreds of hours of footage and audio recordings of Mr. Combs, his staff, and guests engaging in serious illegal activity. Lord have mercy, Jesus. Oh, they got the evidence. Oh, first to get on the plane, baby. Leave him now. They coming to get you, baby. Now, remember what did I tell y'all to do? This wasn't legal advice. We was just talking. Okay? What did I tell y'all to do first? Go and secure the civil litigation first. Then go get criminal. So this is the preamble to what may eventually come in the way of criminal charges. Lord have mercy. Mr. Jones has secured irrefutable evidence of the acquisition, use, and distribution of ecstasy, cocaine, GHB, ketamine, marijuana, and mushrooms. The displaying and distribution of unregistered illegal firearms. Mr. Combs provided laced alcohol beverages to minors and sex workers at his home in California, New York, the U.S. Virgin Islands, and Florida. Mr. Combs' chief of staff, Christina Coram, KK, instructed her staff to retrieve drugs so she can provide it to Mr. Combs for his consumption. Kristen Combs drugging and sexually assaulting a woman. Mr. Combs detailing how he planned to leverage his relationship with Bishop T.D. Jakes. Lord have mercy. To soften the impact on his public image of Cassie Ventura's lawsuit. Young Miami's cousin and or assistant sexually assaulting Mr. Jones. Actor Cuba Gooding Jr. child sexually harassing and assaulting Mr. Jones. Rapper, somebody on Mr. Combs' yacht, consorting with underage girls, sex workers, and R&B singer. Lord have mercy. Please don't let it be Chris Brown. Please, Lord, he hangs with him. He hangs with Justin and them. Oh, Lord. Oh, Lord. I'm out of this game, baby. I got to go. I got to go. Where was the parent? Where was the parent? They lying. They lying on Chris. They lying. Just go get the banner. Go get the sign. They lying. Oh, Lord. R&B singer. Wait a minute. Wait a minute. Wait a minute. It's a footnote. It's a footnote. Hold on. Let me see if I can. Hold on. They gave, listen. See, that's why they paid me the big bucks. Okay, we're going to, let me see. Where my people at? Where my people at? Okay. We so damn know. Okay, number 3. Sorry, let's go down to this 10 little footnote. Okay, he He is a Philadelphia rapper who dated Nicki Minaj. Number 3. That's Meek Mills. Meek Mills, Lord. Meek Mills. Oh, Lord. Jesus Christ. Lord, this I think number 4. Oh, this is Chris. It says he is a Grammy Award winning R&B singer who had trouble with the law enforcement after assaulting a Bajan billionaire. What was Bajan? What the fuck Bajan mean? Hold on. What does Bajan mean? Lord, that's Rihanna. Hold on. What is Bajan? What is Bajan? What is Bajan? Barbados. That's Lord have mercy, Jesus. Oh no. I told you they was coming to get him. Oh Lord have mercy. Oh Lord. Oh Lord have mercy. Oh Michael. Michael. Oh Michael. Oh Lord have mercy. They lying. They lying. They lying. Oh Lord. I can't take no more. I know with some of you niggas in this sector that turn Christian. Oh, I can't stand you niggas. Oh, I'm finna talk about all y'all in this sector now. If he go down, all y'all going down. I'm gonna release it. Mm-mm. 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 Give me my blood pressure medicine now. Oh Lord. Oh, I got the steak. I got the steak. Keller, come get your girl. I got the steak. I got the steak. Oh Lord. We going viral. That's right. We going viral. What? I knew that Beijing, Bajan, whatever that meant, Barbados. You got me fucked up. Listen, we smart over here. You see, I went on down there and found it. I knew it. That's what education gets you. Says go down there. Okay. It says there's a footnote to figure out who these people are. You should have might as well put the name on up in there. We know who the fuck it is. Yeah, who wrote it? Who is Mr. John? Lie. That was Meek Mill. You said he dated Nicki Minaj. Who else could that be? Oh my goodness. Okay. The Shalice Recording Studio shooting. What is this about? On or about September 12, 2022, Mr. Combs held a writers and producers camp at Shalice Recording Studios at 845 House. Present at this camp was Mr. Combs and his son Justin Combs and Justin's friend named G. Mr. G is a 30-year-old tall African American male. Can we go figure who that is? Who that is? In addition to these individuals, the other musicians were present at the camp. This writer has spoken to several musicians who attended the camp. One evening during this camp, Mr. Combs, J. Combs, and G were in a heated conversation. The conversation was moved out of the studio and into the restroom adjacent to where Mr. Jones was sitting. Mr. Jones was approximately 2 feet away from the bathroom when gunshots rang out. Mr. Jones recalled hearing multiple gunshots. Mr. Jones immediately went into a state of shock and feared that he would be shot next. Mr. Jones genuinely believed that he would be shot through the door due to how close he was. After the shooting ended, a crowd gathered around the restroom. When the door finally opened, Mr. Combs and J. Combs exited. G was lying on the restroom floor in a fetal position, holding his stomach and bleeding out of his leg hip area. These niggas going to prison. We going viral, they going to prison. Everyone stood around looking upon G. Frustrated by the lack of aid to G, Mr. Jones dropped everything, ran to Mr. G, and immediately began placing pressure on G's gunshot wound to his stomach. As he was applying pressure on his stomach, Mr. Jones realized that G was gushing blood from another area near his leg, his hip. He decided to lift G and place him to sit on the toilet. Mr. Jones asked the crowd to call the ambulance. Mr. Jones lifted G and brought him to the ambulance at the studio's front. At this time, Mr. Combs and Justin disappeared to another part of the studio. Mr. Combs gave strict instructions to inform the police that he had nothing to do with the shooting. He also forced Mr. Jones to lie to the police by telling them that G was that G was shot standing outside the studio by a drive-by assailant. Lord, they attacked Lord, they got me talking ignorant. I can say they attacked Lord, they attacked the article. Mr. Jones had several cooperating witnesses who spoke with this writer anonymously due to fear of retaliation by Mr. Combs. They have agreed to speak publicly when subpoenaed. Mr. Jones has the clothing he wore that day and believes it may still have stains and the DNA of G's blood. The following are screenshots of the aftermath of the restroom where G was shot by either Mr. Combs or J. Combs. Lord, there's blood. Oh, Lord. Mr. G's outfit all on him. What was Mr. G wearing? That's important. What was he wearing? Was it Prada? Is that Prada? Is that Prada? I can't tell what that is, my love. Okay. Clearly, G was not shot outside the studio as Mr. Combs instructed his team to report to law enforcement. Mr. Combs and defendant LR, MR, UMG, and CRS provided private security for the writers' camp at the defendant's CRS. Okay, so that's how they're going to get them attached to this claim, right? So with all of these civil suits that you've seen coming out, right? They find a way to attach record labels, anybody pretty much with money. Okay. They're doing that by either making it seem like that a person was an employee of that person or the person was doing employment like duties, which a judge can make a determination that that person was an employee of the company, or the company in this case provided security. So that would say, hey, because this claim seems like it may have something to do with safety, maybe a safety issue was involved, or the issue of safety, whose responsibility was safety in this particular matter. Maybe the person that owned the gun had a duty to make sure that that firearm was secured at all times. Stuff like that, right? Can easily attach someone to a claim. It depends on how the judge determines, okay? Or how it's laid out in the court. If it goes to a trial, then how the jury is asked to determine who would be responsible, who's liable, at what point, for what, how the person is attached, and all of that, right? Yeah. You see how sharp I done got? I was fucked up. I was fucking it up. We was talking about Mr. Kelly and all that bullshit. But when it started talking about Chris involved, oh, I'm sharper than a motherfucker. I done woke up, baby. Like what? Oh my goodness. Oh my goodness. Spitfire is gonna talk about this right now. She knows I love me some Chris Brown. Spitfire, don't you do it. Don't you do it. Don't do it. I hate to short with the goddamn water. Don't do it. Shit. He needs his day in court. Don't look at Chris differently. He's innocent. Woo. Okay. Oh, well, if I kept reading, we would have got to it. It said Mr. Combs, defendant, blah, 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 provided private security for the writers' camp at the defendant's CRS. The security was porous and lackluster at best. So we already know what it's going, okay? So some kind of way security, so we know for sure security is going to be a question of something up in this plane somewhere. Somebody's going to be held liable. Okay, it's going to have something to do with some security or something. So the fact that either Mr. Combs and J. Combs were allowed to enter CRS with guns, and those guns were not confiscated by security, is a clear breach of duty by Mr. Combs, defendants LR, MR, and UMG to protect Mr. Jones and other attendees of this writers' camp. Now, what can be a defense against this? Is one, if they signed away the rights, as far as, hey, waive their rights. Let me use more the appropriate word, waive their rights. Okay? And say, hey, you enter at your own risk. Okay? Or if they say it was understood up front that security would be specific for this, that, and the third, and not for Mr. Jones. If they have a sign up in CRS or whatever it is that says, hey, enter at your own risk. If they substantiate at some point that you're entering in at your own, oh, wait a minute, let me put my, where Karen? Where is Karen J? Hold on. I've got to do this now. I'm getting into the weeds with something. Wait a minute. Maybe we just having conversations and dialoguing, baby. That's all we doing. Don't come get nothing I got. And we ain't giving no legal advice or none of that. None of that. Take Diddy, give us our tenant. Okay. What the fuck is going on? Diddy done got my boy hooked up into this shit. Time to fight. That's right, Cookie. Listen, I'm gonna need everybody. What's up, Queen Bria? I'm gonna need everybody in the care sector. I need to borrow some of them pamphlets y'all got, some of them banners and shit y'all got, whatever. I give them back to you when y'all need them. What I'm gonna scratch those out with Chris Brown on there. And then when y'all need them, we can just erase it and go back to our case. Okay? Oh, have mercy. How much sex do y'all need, fellas? What up, Atlas? How much sex do y'all need, fellas? Y'all need to evaluate this. Oh, jeez. This crazy. This scandalous. Let's keep on. Let me see what. Okay. Let me see. Okay. It says, as a result of this shooting, Mr. Jones is severely traumatized. Mr. Jones now suffers from PTSD, severe anxiety, depression, and insomnia. Hell, I got that too. As of when I read it was Chris Brown. Mr. Jones was sexually harassed and assaulted by Mr. Combs. Throughout his time living with Mr. Combs, Mr. Jones was the victim of constant, unsolicited, and unauthorized groping and touching of his anus by Mr. Combs. Seems like me, it was a choice. Hey, y'all. Hey. I sound like a blank supporter. See, like me, it was a choice. I sound like Kanye West. What you mean? You couldn't get out of that? Hey, did you go back to work the next day? Why you pull a twist and keys on? It's your real name. I'm gonna need all y'all doctors and all that shit. Find out this man's real name. Rodney Jones. Yeah. Look your ass up, Mr. Jones. Is you everybody else gave us that old ugly picture of Puffy? You're lying. These events took place in LA, New York, Florida, and United States Virgin Islands. In addition to the unsolicited and unauthorized touching, Mr. Jones was forced by Mr. Combs to work in Mr. Combs' bathroom to work in Mr. Combs' bathroom as Mr. Combs walked around naked and showered in a clear glass enclosure. As a heterosexual Christian man, Mr. Jones was uncomfortable with Mr. Combs' advances and expressed his discomfort to Mr. Combs' Chief of Staff, Christina Caron, KK. KK responded to Mr. Jones' complaint with, you know, Sean will be Sean. KK also attempted to downplay Mr. Combs' groping of Mr. Jones' anus and genitals as friendly horseplay, stating that those acts were Mr. Combs' way of showing that he liked you, Mr. Jones. Despite these assurances, on several occasions, when Mr. Combs began to undress and walk around his house naked, KK would say, okay, I'm leaving now, and she would disappear. KK's hypocrisy is breathtaking at best and enabling at worst. Mr. Jones believes that KK aided and abetted Mr. Combs' sexual assault of him and was working with Mr. Combs to groom him into accepting a homosexual relationship. Through these sexually deviant acts, one would say Mr. Combs has a pattern of practice of engaging in such nefarious activity. This ongoing conduct shows that Mr. Combs cannot be rehabilitated. Mr. Jones, if you write down anything about Chris Brown running up into your ass, I'm telling you that right now, you're going to have to move. You're going to have to move your mama. You're going to have to move your mama. Oh, my God. Mr. Combs attempted to groom Mr. Jones into engaging in the gay sex. Mr. Combs was aware that Mr. Jones looked up to and idolized music producer Stephen Aaron Jordan, Stephen J. Stevie J is an American DJ, record producer, and television personality. He be on Love and Hip Hop Atlanta. He was on was it just Atlanta? Oh, he was on in Love and Hip Hop LA as well. Stevie J was part of the Bad Boy Records production team in The Hitman Men. In 1997, Stevie J won a Grammy Award for his work on Puff Daddy's debut album. Throughout the late 1990s, Stevie J produced for several artists, including Mariah Carey, Kevin Campbell, Notorious B.I.G., 112, Jodeci Faith Evans, Jay-Z, and Eve. Stevie J was one of the producers of the Love album. Mr. Combs used access to Stevie J and his knowledge of Mr. Jones' admiration of Stevie J to groom and entice Mr. Jones to engage in homosexuality. Seems like you want to do it. Mr. Combs went so far as to share a video of Stevie J anally penetrating a Caucasian male without a condom. This was done to ease Mr. Jones' anxiety concerning homosexuality. According to Mr. Combs, this is a normal practice in the music industry. Just look at it, even Stevie J is doing it. Mr. Combs informed Mr. Jones that he engaged in sexual intercourse with rappers. Okay. Lord, they naming some more people. If they name Christopher, I promise. I'm listen. Okay. I can't do this. I ain't cut out this. Y'all need this somebody else. This ain't what I come to do. Hold on. Mr. Combs informed Mr. Jones that he engaged in sexual intercourse with rappers 5, R&B singer 6, and Stevie J. Please, love, please don't let it be. Please let me scroll down here and see the key. Please don't let it be. 5 is a Philadelphia rapper. That's Meek Mill. 6, he performed at the Super Bowl and had a successful Vegas residence. That's us. 7. Wait a minute. I ain't got 7 yet. I'm about to have. I gotta take. Let me take my blood pressure pill. Let me go on. My head is swelling back. I'm gonna look like a Chinese by in the morning. Mr. Combs promised to make sure that Mr. Jones wins Producer of the Year at the Grammys if he engaged in homosexuality. The following screenshots of video 7 of Stevie J anally penetrating a Caucasian white male that Mr. Combs provided to Mr. Jones. Okay, the following screen of video 7. The writing is possession of the video and will provide a copy to the court. Thanksgiving 2022, Mr. Jones was sexually assaulted by young Miami's cousin. On Thanksgiving Day 2022, Mr. Jones was in Mr. Combs' house located in Miami, Florida. Young Miami and her female cousins were also present. Mr. Combs was intoxicated and offered cocaine to Mr. Jones. Mr. Jones rejected him and proceeded to walk to the restroom. While using the restroom, young Miami's cousin burst into the bathroom and began groping Mr. Jones. Mr. Jones believes that Mr. Combs sent her in there to sexually assault Mr. Jones. So you ain't like being groped by the men or the women? How long your motherfucking ass was in this situation, sir? Because at this point, it seemed like a volunteer. If you was over age. Yeah, she can switch. I ain't laughing about what happened, whatever. I'm actually just in shock, really. This is crazy. These people, this some shit here. This some bullshit. I mean, the entertainment biz, if all this shit is true, this is some crazy shit. They get high up on these drugs and stuff like that and just do all kinds of stuff. Make out with rabbits and shit. The fuck? Says while using the restroom, okay. So as she entered the bathroom, she dropped to her knees and began performing oral sex on Mr. Jones' exposed penis. Mr. Jones pushed her away and exited the bathroom. Young Miami's cousin did not accept Mr. Jones' rejection as she proceeded to follow Mr. Jones out of the bathroom. She started undressing and attempting to straddle him and have sex with him in the presence of Mr. Combs and his staff. Once again, Mr. Jones pushed her off. The following images from a video of Young Miami's cousin, Mr. Jones, and Mr. Combs. Is that? Oh! Mr. Jones and Mr. Combs on Thanksgiving Day, right before Mr. Combs invited Mr. Jones into the restroom and attempted to force him to take cocaine. Young Miami and her female cousin who sexually assaulted Mr. Jones on Thanksgiving Day. Ooh! What kind of shit is this now? Mm-mm. This is crazy. Y'all hold on for a minute. This is crazy. This is crazy. I can't take no more of this. Let me put y'all on some soothing music or something. I can't even speak. Y'all don't want to know something about the Waffle House no more, so. Lord have mercy. They got Chris.
Buy a zip of weed, hit the club, pay for about 10 niggas to get in. We crunk, lit, in it, bitch. Yeah.
We walk around the world, stepping out, giving a damn by where our feet lined up. Yeah. Get your ass mushed, smushed. Yeah. 21. Biggest. To the nigga in the chicken man. Pussy.
21, can you do something for me? Can you hit a little rich flex for me? Then 21, can you do something for me? Drop some bars to my pussy ex for me. Then 21, can you do something for me? Can you talk to the ops next for me? 21, do your thing, 21, do your thing. Do your thing, 21.
Yellow diamonds in the watch. This shit costs a lot. Never send a bitch up die. That's how you get shot. I DM in Spanish mode. I do that shit a lot. Took her panties off and this bitch thicker than a plot. All my exes ain't nothing. Them hoes busted. If my ops ain't rapping, they ass ducking. You ain't ready to pull the trigger. Don't clutch it. I know you on your period, baby. Can you suck it? I'm a savage. Smacker, booty, and magic. I slap a pussy nigga with the ratchets. Might slap a track on this whip and get the addicts. Don't call me on Christmas Eve, bitch, call your dad. Bitch, call your uncle. Bitch, don't call me. Always in my ear, your whole fleet. Why my auntie posting guns and only you say feet? Hey, like an athlete, I got
All you hoes, all of you hoes, need to remember who y'all talking to. It's a Slaughter Gang CEO. I got dick for you if I'm not working, girl. If I'm busy, the fuck no. You need to find you someone else to call when your bank account get low. You need to find you someone. Hey, 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 I'm on this Slaughter Gang shit. Hey, murder gang shit. Hey, Slaughter Gang shit. Hey, murder gang shit. Hey, sticks and stones, chrome on chrome. That's just what a nigga on. Internet calls got 'em kissing through the phone. Cookies clicking up so they don't feel alone. Hey. Man, niggas seeing me, I'm young money CMB. I used to roll with CMG, the house is not a BNB. The bad bitches waiting on a nigga like I'm PND. I'm steady pushing P, niggas pushing PTSD. I told her ass to kiss me in the club, fuck a TMZ. I used to want a GMC when what was doing B&E. We revving up and going on a run like a DMC. I lay up with her for a couple days, then it's BRB. Rappers love asking if I fuck when you know he did. Well, you know he did. She came in heels, but she left out on a cozy shit. Hey, I'm living every 24 like Kobe did. Shout out to the 6, RP to 8. Swear this shit is getting 8. I'm on 10 for the cake. Get a lot of love from 12, but I don't reciprocate. 51 division, stay patrolling when it's late. 21, my Eddie, so the knife is on the gate. All the dogs eating off a Baccarat plate. Niggas see Drake and they underestimate. Take it from a vet, that's a rookie ass mistake. Hey. Why, look, you the motherfucking man. Why you? Woo, you is the man. Yeah.
Too many subscriptions? You can keep track of them with Rocket Money. I just found out that I've still been paying for Prime after I canceled my account 3 years ago. So my friend got me on the Rocket Money app to help me manage my subscriptions. The app shows you all of your expenses in one place. They make it really easy to link your accounts. And in minutes, I was shocked to find out that I'd been paying for not only Prime, but several forgotten subscriptions. I'm sort of embarrassed to admit this. I really do try to keep close track of what I'm spending, but Rocket Money proves how complicated some of these charges can be. The best part, the app conveniently cancels your subscriptions with literally just a tap. They did all the work for me. They even tried to get me a refund on some of my wasted money. I canceled 3 different subscriptions the very first time I used this app and ended up saving almost $600. If you're a visual person like me, it is extremely helpful to see all of your charges in one place. That way you can stop wasting your money on subscriptions you don't even use. Trust me, you will not regret using this app. Download Rocket Money today to start managing your money better.
yeah. Life. Life is the only thing we need. They need me to go, but I don't want to leave. Rest in peace, Lil Key.
Fuck a pigeonhole, I'm a night owl, this a different mode. I might have to make a pen of 6 on a pinky toe. Heard you with a shooting guard, just let a nigga.
This is some sad shit. My steak don't even taste right. You got to be kidding me, right? It's just crazy. The NBA and the Ruffles mess with CB. Oh, the NBA and the Ruffles. What you talking about, Karen J? What you talking about? What now about Chris? What now? What? Girl. Listen. Also, it says throughout the time, his time with Mr. Combs, Mr. Jones was transported from California to New York, Florida, United States Virgin Islands. There's RICO. During this time, Mr. Jones was forced to solicit sex workers and perform sex acts to the pleasure of Mr. Combs. On or about February 4th, 2023, Mr. Combs forced Mr. Jones to bring prostitutes and sex workers back to his home in Miami, Florida. I told y'all, go for the civil first, then, if you want to, go to, then you could pursue criminal. Well, actually, you could do it both ways. You could do it both ways. I take that back. You could do it both ways. I just thought about it. Well, what is this now? Sex workers. Well, where are damn shoes at? Oh, wait a minute. No, okay. I mean, he in there like snitching. On or about February 2nd, 2023 incident, Mr. Jones believes Mr. Combs drugged him. Mr. Jones recalls waking up naked, dizzy, and confused. He was in bed with two sex workers and Mr. Combs. He also recalls aimlessly wandering around the house with no clothes on. What is this now? What is that? Can y'all see my mouth? What is sex worker? Sex workers in sex workers in Mr. Jones' bed in the morning after being drugged. On another occasion in Miami, Florida, oh Lord, on Thanksgiving night of 2022, Mr. Jones asked Mr. Combs and Mr. Jones and DeForest Taylor to enter into the studio bathroom. He asked them for $100 bill because he wanted them to do cocaine with him. So let me ask y'all this. Okay, all the cocaine smokers in the chat. Let me ask y'all a question. And if any of y'all are cocaine smokers that's in the cloud, y'all gonna help me answer this question. I need anybody that smoke cocaine or know of people that smoke cocaine. Do you have to use $100 bill? I don't be liking for nobody to call me shelter and stuff like that because I swear I'm deep in the street. But do you have to use $100 bill? I was using $100 bill. Any cocaine smoker? No. You don't have to use $100 bill. You can use like a 5 or a 1. That's got to be expensive. You got to buy the cocaine, and then the only thing you can use is $100 bill. I was wondering why they was having like $100 bill with the snorting cocaine. Like you could use something smaller. I don't know how this go. I can't really just pick up the phone and ask nobody because I don't know nobody that smokes no cocaine. But you motherfuckers, I don't know about smoking cocaine. If I was gonna smoke cocaine, I would use something less flammable. Okay? No. Okay, Danny. Hey, Danny. Little baby Danny might not be a little baby after all. Mm-mm. So this steak don't even taste right. I done wasted all my good peppers. Shit, these are expensive peppers on this good steak. Okay. Mr. Jones was scared, but luckily he didn't have $100 bill. So Mr. Jones waited a little later to do coke with young Miami. Okay, it seems like you still volunteering, Mr. Jones. Later that evening, he required Mr. Jones to solicit sex workers from Bobby Trap, from Booby Trap on the river, from sex workers from Booby Trap on the river located in Miami. Mr. Jones did so, and Mr. Combs forced him to engage in unsolicited sex acts with these workers. That's like that's a cab. Booby. No, this is Lord have mercy. That's some kind of dance club or something. See, listen. This is why y'all need a friend like me. I don't allow you to get into these type of activities. Mm-mm. I done talked to many people out of wild nights. Y'all just don't understand. And I don't need nothing to be happy, sad, up, down, positive or negative. It's all natural. I don't take no vitamins, which I should. I mean, ain't nothing wrong with taking vitamins. I don't, use nothing to get me hype, nothing. You know what I'm saying? I can do that myself. It's a natural force, natural, power. Y'all need to invest in that shit. All this sex is just I mean, some kind of disguise, tactical, and this place gonna look like you can get you a burrito and a margarita. It's some place to order some ass out of. What the fuck is going on? And this ain't no ribeye steak here either. Where is Karen J? My nerves got bad. She a whisper, not whisper my ass. Okay, as part of Mr. Jones' sex worker recruitment tools, Mr. Combs provided Mr. Jones with an exclusive bad boy baseball cap and required him to wear it to booby trap on the river as a signal to any sex worker he approached that Mr. Combs was in town and had sent Mr. Jones to recruit them. This sounds like a movie script. So now they got a covert way of soliciting some ass. Well, they need to do it like we do it in here. You come in here, we actually you're buying or selling. That's ass, that is. Mr. Jones had no desire to visit booby trap on the river. Mr. Jones had no desire to solicit sex workers from booby trap on the river. I guess Mr. Jones would know I also to call the police. But let's keep reading. Mr. Jones used his power, Mr. Combs used his power and influence to intimidate and force Mr. Jones into soliciting sex workers from booby trap on the river. As detailed below, Mr. Combs used many tactics to maintain dominion and control of Mr. Jones. Apparently, these workers were accustomed to servicing Mr. Combs and would know that he is in town by the sight of the bad boys' baseball cap. The following are Instagram profiles of two sex workers that Mr. Combs required Mr. Jones to solicit and have sex with at his home in Miami, Florida. Don't bring that shit in. Don't shoot me, shoot Larry. Look at me, my ears ass. I'm trying to click on the damn sound. Mr. Jones had no desire to solicit or have sex with the individuals in the previous paragraph. Mr. Combs used his powers and influence to intimidate and force Mr. Jones into soliciting and sleeping with these women. Now, hold on. Hold on. Now, Puffy's defense team gonna tap Mr. Jones' ass up. Let me modify something. Depending how strong your cases are, is when I would suggest just out of just having a conversation, whether you determine whether you want to go criminal first and then civil. Because this dude isn't a helpless, a young girl. He's a dude, which doesn't really mean nothing. At any time, he could have left. He could have alerted authorities. No, what he did was participate. Mr. Jones, do the best you can. Before I let you send Chris Brown to jail, I'll turn man. Okay. The following is the phone number of another sex worker that Mr. Combs required Mr. Jones to solicit and perform sex acts with at his home in Miami. AG. Baby, I can show you somebody in my phone with saved under AG. And I said we had the same initial if we would have got married. As a matter of fact, I done showed y'all. I'm be up all night because I'm nervous for my boy Chris. It says Mr. Jones had no desire to solicit or have sex with the individual in the previous paragraph. Mr. Combs used his power and influence to intimidate and force Mr. Jones into soliciting and sleeping with individuals above. Mr. Combs used many tactics to maintain dominion and control of Mr. Jones. He promised him a Grammy for Producer of the Year for the Love album. He offered him $250,000 to purchase all of the instruments he wanted. He promised him ownership of his $20 million property, One Star Island in Miami, Florida. He promised access to record labels executives like defendants Lucian Charles Grange and Ethiopia Habit to Mariam Mr. Combs would often switch up his approach. He would go from promising Mr. Jones the world to threatening Mr. Jones with physical harm. See, that's what you should have had alleged throughout this claim, because majority of it sounded like you was a volunteer, sir. You should have been more like physical harm, um, threats like being blackballed, like I'm saying, like, you know, Puppy said they'll put some photos out of you if you didn't do it. We say that type of shit. If you know, we'll implicate you in it too if you tell on us and stuff like that, sir. I mean, with this might mean you might be telling. No, I don't know. I don't know. Maybe he thinking that the money done dried up after, you know, he sees what's going on. Now he's thinking maybe this is the best way he can get out of this relationship. And I'm not saying like a love relationship with Puffy, but this relationship with Puffy, this situationship, and to leave with some money. You understand what I'm saying? Because mm-mm. Dude. Okay, Mr. Combs threatened to eat Mr. Jones' face. Huh? Mr. Combs threatened to eat Mr. Jones' face and informed Mr. Jones that he is willing to kill his mother, Janice Combs, if he must, in order to get what he wants, so he wouldn't think twice to harm Mr. Jones. Okay, when did that start? Okay, was this a time frame? Y'all, we always over him. We always looking for, although the paperwork that comes out usually is always in favor of what the party that brings it, right? Which is usually the prosecutors or the plaintiff in these claims, right? But we always have to keep our defendant slash defense hat on and trying to figure out how to rebut a lot of this shit, how to defend this stuff. We always got to think like that. You know I'm delirious because that is what I tell my class. Not y'all motherfuckers. So pardon me, I ain't talking to y'all. Mr. Combs and J. Combs solicits drugs and engages in illicit sex acts with minors and sex workers. Oh Lord, please don't reference Chris. On about July 2nd, 2023 in California, Mr. Combs had a listening party at his home. Present at his home was R&B artist 9, J. Combs, sex workers, and some underage girls. Let me see who 9 is. Oh Lord, it's Chris again. Oh Keller, I need you, Keller. Help me, Keller. I got the trembles, Keller. I got the trembles and I'm breaking out with the mumps. Keller, please help me. Oh Lord, and my steak nasty. Mm-mm. Ain't nothing but you janky ass niggas that's causing this here for Chris. Oh Lord. What they lying, Chris, they said Chris did. It says the event began at 7 p.m. Mr. Combs requested female workers and required Mr. Jones to solicit them. An hour later, several sex workers appeared. In addition to sex workers, there were at least 5 women in the crowd that were under the age of 16. Mr. Combs forced all the women to drink Lace de Leon liquor upon information and belief that Mr. Combs laced the liquor with ecstasy. Mr. Combs did not take the identification of any of these underage girls. The presence of these underage girls women made Mr. Jones very uncomfortable. He attempted to leave and Mr. Combs forced him to stay. Okay. Mr. Jones went as far as to take Mr. Jones' car keys to prevent him from leaving. That's what more crazy ass niggas do. Sound like a relationship to me. Hey, y'all in the chat. Let me know by the show of typing some words in the chat. How many of y'all done had the men take the keys to prevent you from leaving, or take the keys and throw them in the woods? Well, like not in the woods, but like in the grass and stuff like that, where you can't find your keys and stuff to prevent you from going. That's what it sounds like to me. We got a mount of defense. You too, Cookie. They done took your keys. The men done took your keys too. And men, if you done took the women keys to prevent the woman from leaving, throwing them around and stuff, locking the door, type it in the chat that you did. We ain't making this shit up. This done happened to us. And listen, if y'all want to, ladies, if y'all want to, it's totally up to y'all. Cause I'm up now. If y'all want to have this nigga done gave me PTSD power live, let me know if y'all want to do that. Cause we can talk about we'll do, oh my goodness, and we might play on their phones tonight. Yes. 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 We might play on credit card man's wife's phone tonight. Hey, can you do star 67 on your cell phone? Jump on your hood, yep. Stand in front of your car, all of that. Yep. Deep Watson, I ain't never took I ain't never no keys, so I can't leave. Maybe you mean you took their phone and not their keys, so they couldn't leave, Debbie? Y'all come on out the clouds and tell us, y'all crazy ass niggas and dog. Y'all already been identified as crazy anyway, but we know you done it. Kelly, what you done did? Cause you know I know, but you know I know the information about you. What have you done and what have been done to you? Yeah. Y'all let me know if y'all want to have a PTSD meeting. So, Debbie, while you took the phone or you took the keys and threw it or the phone? Bye. What about, and I don't want to open up no old wounds, Keller. What about, you know who what happened with that, with the little crazy stuff with who. I'm gonna keep reading till I get. I'm gonna check back for some more answers. Mm. Okay. Mr. Combs did not check the identification of any of these underage girls. So right there, he's showing that Mr. Combs did not at least take some level of precaution to secure to try to ensure that he didn't have any underage girls in his presence, right? The presence of these underage women made Mr. Jones very uncomfortable. He attempted to leave, and Mr. Okay, wait a minute, when I okay. After being forced to drink Lace de Leon shots, Mr. Jones began feeling lightheaded and recalls passing out and waking up at 4 a.m. the following morning naked with a sex worker sleeping next to him. Screenshots of a video 10 from that night is embedded below. Okay, now this is what we're gonna be start looking for by Mr. Jones, his lying ass. Okay, this happened July, right? Let's see if Mr. Jones has some more story. Cause he want to throw Chris, talk about Chris and shit, bitch ass nigga. Okay, so this is Puff Daddy getting it in with somebody. So check this out right here. Okay, who's taking these photos or running these videos? If it ain't Mr. Jones, who is doing that? The writer in possession of the video will provide a copy to the court. This writer is in possession of the video and will provide. Okay, so who is the writer? Huh. Mr. Combs was an underage female sex worker. Justin Combs with an underage female. Well, where is she? Okay. Mr. Combs attempts to pass off Mr. Jones to Cuba Gooding Jr. Girl, they got Cuba Gooding Jr. in this shit. You can't make this up. I told y'all that these celebs, they live. But I was always respected because I don't do stuff like this. Let me tell y'all something. And Cookie, I got a deep, dark secret I need to tell you about. Where you at, Cookie? Where's Cookie? And I don't want y'all to judge me. Let me tell you what I did. And I felt, still feel a little terrible about myself because I did this. I put like this. I feel terrible about myself when I think about it because I thought about it the other day. Every fall, the fair comes here, right? So usually it used to be a thing when me and Yvette get together, take the kids to the fair together, right? Now, I mean, we was taking the kids and they were damn near grown to the fair. That was her and our special friend thing we used to do. Okay. Remind you, like, she was my best friend majority of my life, right? And I do miss her, in and out, but it is what it is. I think how we normally start back talking is that we run into each other. But this is the longest time we've ever gone without talking. We'll run into each other and just start catching up and talking, like it was, you know, like nothing else, whatever. But of course, if we have a whole bunch of stories to tell each other, and a bunch of new friends to introduce each other to, because since we've been separated. But anyway, so for this particular time, as a matter of fact, I went to a fair on a separate night. I went by myself. And when I got there, probably about 30 minutes in, I met this dude named Tariq. I'll never forget it. I met Tariq, and our type of the kind of, and now I guess I'm using this word, the type of energy that we was giving off was one where I usually don't do. Like, there's no way I'm going to meet you and then the same time frame you standing all close to me and all the stuff. It's almost equivalent, like you meet somebody at a club and you're dancing all close to them and stuff like that. I don't do that. You know what I'm saying? I don't do that. We not rubbing up against each other. Now, if we a couple, we may dance a little close, but you're not going to. I'm not going to bend over. You're not going to grab on my ass. We're not going to be doing all that closeness together on the dance floor. And another thing you're not going to do that thing. You know how men get behind you and have their hand up like they finna beat you, spank your ass and stuff like that. I don't play no shit like that. I'm a decent hoe, and all my hoes are decent. Okay, I don't do no shit like that. I'm gonna tell you what happened. So the kind of energy we were like, it was like a I don't want to say it was kind of, I guess you could consider it flirty, because you know he wasn't on my butt or anything like that, but he was real close to me, and he would whisper stuff in my ear and stuff like that. When From the time we locked eyes, we walked around that whole fair together. He went to win me a beer and stuff like that. He was doing all that type of stuff, as if he was a regular, like my regular dude, right? I'm gonna tell you what happened. So when it was time to leave, right, we had done exchanged numbers. I did something I still feel so dirty to this day. I want to go just take a bath now thinking about it. You know what I did? I went to his car. I got in his car, and you know what? We kissed. Yeah, that was the first and only time I kissed somebody that I had just met. I feel like, oh my God, I feel so bad telling y'all this. And I've only told one other person this in my life. I felt so ashamed. Was Yvette. That's the only person that knows this. Yeah, I kissed somebody when that I first met. And we went on maybe about 3 or 4 dates, and we talked maybe like about 4 weeks or whatever, and we just finally, and nothing never came of it. I never had sex with him, nothing like that, no shit like that. But yeah, but I kissed him. I met him about 30 minutes in at the fair after we had went there, because we had something called Midnight Mass. So you know, it like starts at midnight and then around like 6 o'clock or whatever, you take your ass on home, whatever. And it just, you know, because the fair goes, I think it was on Friday, Saturday, on Friday and Saturday, it stays open all night. But on Friday, that's when the Midnight Madness was. That was special prices. And, you know, you ride all night on one armband. You know, you play like a price to get in and you ride all night on one armband. Yep, I kissed him. Yep. No, it's not. It's not just a it's not just a kiss. I mean, that was terrible. Yeah, I kissed him. I'm bearing my soul. Like, don't call me no hoe, please. I mean, shit, I made a mistake. Y'all think I think I'm perfect. Okay, well, there's right there. I told y'all I don't think I'm perfect. That's a deep flaw right there. I done kissed that man, Tariq. And that's a goddamn shame. I don't remember his last name. I was a whore for like 8 hours. Walking around holding hands and shit. I didn't know that damn man. You know him? Yeah. No, if you don't lost respect for me from a kid, I am. Listen, I don't know what can I do to get it back, but I did. I kissed that man. He was very cute. Mm-hmm. Mm, 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 mm. Yep. I'm home. I'm home now. That's some whole activity right there. I guess I get mine when I get my first tattoo, but I hate them. But you can't get no tattoos in this family. That ain't happening. I don't want it anyway. But if I get one, I'm going to get one that's a hole. I'm just gonna put a hole on it. Hole. Hole attorney at law. Okay, let's see. All right, it says Mr. Combs attempts to pass off Mr. Jones to Cuba Gooden Jr. Huh? Mr. Jones believes that Mr. Combs was grooming him to pass him off to his friend. This fear became reality when Mr. Combs introduced Mr. Jones to Cuba Gooden Jr. while they were on Mr. Combs' yacht. During the introduction, Mr. Combs suggested that Cuba get to know Mr. Jones better. He then left them alone in a makeshift studio on the yacht. Ooh, that is Cuba Gooding Jr. Mr. Combs and Cuba Gooding Jr. moments before Mr. Jones is assaulted. As evidenced by a video of which screenshots are embedded below, Cuba Gooding Jr. began touching, groping, and fondling Mr. Jones' legs, his upper inner thighs near his groin, the small of his back near his buttocks, and his shoulders. Look, ain't nobody gonna start doing all this freak shit to you. Kelly. Kelly said get thought in Chinese. Oh, Kelly's calling me a thought. Kelly, I'm your partner. I'm your thought partner. Oh no, I'm a thought. Oh, I'm Tatiana. Kelly, you done lost respect for me if you had some. I was young. I still should have known better. I didn't let him touch my breast or fondle me, anything like that. But we just kissed a whole lot in that car. It was very irresponsible of me because he could have been the motherfucking Duval slash. He had pretty hair and pretty eyes. And I liked his name, Tariq. And it was spelled Tariq. I never forget that. Kelly called me a thought. Don't tell nobody that I done kissed somebody the first time I met him. Don't tell nobody that. Because I ain't never told nobody that but Yvette. And I was so embarrassed of that. I was ashamed of that shit. Here I go out there to the damn fair kissing on somebody. Mm, 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 mm. I won't give up no ass. That ain't what I do. Anyway, so let's. If we ever have a party, we don't have to make it a masquerade ball, because I'm gonna have to wear a mask for real, for real. I mean, listen, when I started with the head and face breakout, honey, I was kind of self conscious, but not really, not embarrassed, but kind of self conscious. I have a full head, like a ski mask, like it's a Nike though. It has nothing but my eyes out, my head, my nose, and my mouth. The whole thing is covered down to my neck. I wasn't fucking around. I didn't know what the hell was going on. I got me a mask, baby, a whole head, a full head mask. But they're stylish when if you know how to do. So let me see. Okay, it says Mr. Jones was extremely uncomfortable and proceeded to lean away from Mr. Gooding Jr. He rejected his advances, and Mr. Gooding Jr. did not stop until Mr. Jones forcibly pushed him away. The following is a screenshot of the encounter with oh Lord, with Cuba Gooding Jr. Oh, I'm on the ground, y'all. I'm on the ground. Who is taking this shit? Who is who? Kill the cameraman. Why is the cameraman still breathing? Man, y'all gonna have to start working on all these love albums and shit like that, because this shit's coming back to hunt y'all motherfucking ass. Oh no. Cuba Gooding Jr. forcibly touching Mr. Jones on Mr. Combs' yacht. Oh, we got to go to the footnote. Mr. Cuba Gooding Jr. has a storied history of sexually assaulting and forcibly touching individuals against their will. I ain't never hear nothing about no men though. Throughout his time with Mr. Combs, Mr. Jones was under an implied work for hire agreement. So remember I told y'all earlier how people who sue others and they want to make sure they get paid from somebody. Okay? How they try to make sure people are responsible or companies are responsible. This is, you see what it says? Mr. Jones was under an implied work for hire agreement. So it may be that there is no formal written contract, involved. It could be a verbal contract. It could be determined based on Mr. Jones' act, the duties he performed. That it implies that he was a worker. Okay, therefore somebody should be responsible. Remember, if y'all rewind the tape back, I told y'all, ways that attorneys or just in general, people who bring lawsuits try to make sure that they are guaranteed payment if a judgment swings in their favor. And that's by making sure you get a big corporation that has some money. Because, it's kind of tricky when suing people, okay? Individuals, especially individuals with no company, it's kind of, sometimes they can get these judgments discharged or fight it or whatever, get severely reduced to pennies and stuff like that. And you want to make sure that you have a company, that you can hold a company or somebody with money liable. But first you got to establish the relationship in which it would make them liable. Okay. He was not compensated for his time living with Mr. Combs or for the songs he produced. As evidence, he was listed as a producer for the following songs on the Love album, final release: Deliver Me, Stay, Part 1, Reaching, What's Love, Stay a While, Moments, Need Somebody, Homecoming, and Tough Love. Now, Homecoming, what Homecoming? Is that P. Diddy's Homecoming or Beyonce? So why is he looking at that man like that? And that look like apples. It says Mr. Combs and defendant LR, MR, UMG, and all benefit from Mr. Jones' work product. They failed to compensate Mr. Jones for his work. As a result, Mr. Jones and defendants LR, MR, UMG were all unjustly enriched at the expense of Mr. Jones. Mr. Jones attempted to work with Mr. Combs to secure his publishing and royalty rights for the work he completed on the Love album. Mr. Combs only offered Mr. Jones $29,000 for 13 months, 1,000 hours of work, and 9 songs that made it to the Love album. Ironically, Mr. Jones was willing to take 50 grand, his publishing and royalties. Mr. Combs' self-serving greed would not allow him to pay Mr. Jones an additional $21,000. Mr. Combs' deceptive business practices became so bad that Mr. Jones was left with no other choice than to make a public plea on social media for Mr. Combs to pay him for his work. Uh-oh. Ooh, this might be a good one, y'all, that we gonna follow up. You know why? Because this can be some kind of spite by Mr. Jones, you know what I'm saying? Or retaliation for not being compensated to turn all of this, all these things that he was willing to do at the behest of himself. And if he, if they can show that he also benefited from this sex and all this other stuff or whatever, this might Puff Daddy might have uh a good defense. Mm-hmm. So Mr. It says, after publicly requesting that Mr. Combs do the right thing and pay him fairly, Mr. Jones received an onslaught of threatening messages from Stevie J and Love Records and A.R. DeForest Taylor. Well, who ain't got no shirt on? Well, who's the light skin over there? Okay, the forest line 2. You playing. I'm in the studio. Research talk. LOL, you 100% liar and weirdo. Good luck. Numbers still same. Running to nigga. Come talk to me in public on a public podcast and forum. Okay, so which one would be okay? Hold on, let me look at my phone. Which one would be the hold on, let me look at my oh, so the forest is okay. The forest is the one that's in the black saying you playing. And I guess whomever is in the blue, I'm in the studio. Okay. Mr. Combs used his power and influence to threaten and intimidate Mr. Jones. According to Mr. Jones, Mr. Combs is very forceful and demanding. Mr. Combs does not take no for an answer and would often threaten to inflict bodily harm on Mr. Jones if Mr. Jones did not comply with his demands. As detailed above, Mr. Combs threatened to eat Mr. Jones' face. Fortunate as the A and R of Love Records, DeForest Taylor did not require Mr. Jones or any of the other creative musicians or artists to sign an NDA. So he can speak on it. On another occasion, while standing in Mr. Combs' bedroom, Mr. Jones was forced to watch as Mr. Combs displayed his guns and bragged about getting away with shooting people. Mr. Combs shared that he was responsible for the shooting in a nightclub in New York City with rapper Shine. Ooh, ooh. Now watch Eugene Deal come out here and act like he know all about this and say that like yeah, he'll try to make like he was there. We all know Eugene been gone. And it was, you know what? And I don't just just believe or think that the person is lying just right off, right? I sit and I listen and I try to evaluate what they're saying. But early on, it was something that told me, I don't know. I took for granted that how Mr. Deal carried himself like he was or OG that was, concerned about what was going on. That maybe he was telling the truth. But now, after, how he just seems to be an old goddamn clout chaser, I don't leave it there. Mm-hmm. Cookie, Cookie, you said you want the link. It says he shared that artist and Mr. Combs' girlfriend at the same time, Jennifer Lopez, aka J Lo, carried the gun to the club for him and passed him the gun after he got into the altercation with another individual. The shooting in Shalice recording studios confirmed Mr. Combs' statement. These statements reinforce Mr. Jones' fear of Mr. Combs and strengthen Mr. Combs' dominion and control over Mr. Jones. Mr. Jones was terrified of Mr. Combs. He felt like he could not tell him no. See, so right now they're laying out the defense as to why he didn't like stop doing his stuff, or he went through with what he was doing. Because quite naturally, the trial facts, which is the jury or the judge, is gonna want to know, well, why you kept on going, why you kept doing this stuff. Mm, 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 mm. Mr. Jones was terrified of Mr. Combs. He felt like he could not tell him no. Mr. Combs consistently made it clear that he has immense power in the music industry and with law enforcement. Mr. Combs made it clear that his head of security, Fahim Mohammed, Mr. Mohammed, had the power to make people and problems disappear. I was at the same Mohammed from the thing. Well, who is that? Hey, Fahim. Fahim look a little short. Mr. Combs instructs his staff to always contact Mr. Muhammad if they are ever pulled over by the police in Miami or California. Upon information and belief, Mr. Muhammad spoke with the LAPD after G was shot at CRS. The LAPD was in CRS and witnessed the blood in the restroom, and they went, "What up, Kim?" And they went with the bogus claim that the shooting of G occurred outside the studio. This was all thanks to Mr. Muhammad's connections within the law enforcement. Mr. Jones had no reason to disbelieve Mr. Combs, as he had seen firsthand through the shooting of G and the subsequent silence of the LAPD and the media that Mr. Combs indeed had the power to harm him. The LAPD spent hours in CRS after the shooting of G, yet there were no arrests. Mr. Jones witnessed the LAPD in the restrooms pictured above, yet no arrests were made. The morning after the shooting, Mr. Jones and several others arrived at CRS, and G's blood was still on the floor of the restroom, and Mr. Combs hired a cleaning crew to clean it up. Defendants Ethiopia have Marion aided and abetted and profited off Mr. Sean Combs' RICO enterprise. Give me one moment, y'all. I gotta use the restroom. Why y'all said cooking wanted the link? Hold on.
Plain chicken. Again? Pinky Palmer? Listen, Suze. HelloFresh makes eating better exciting. Smells good. Because it is good. How long were you in the fridge? A long, long time.
Come on, y'all. Come on, y'all.
Love baby, got my raw raw. Yeah, I like the raw raw. Love baby, got my raw raw. Yeah, I like the raw raw.
Find somebody real and you problem. Bring your girls to the crib, maybe we can solve. Hold up, tell them some die. Taking hella long, give it to me now. Make that thing pop like it's in me over now. Ooh, baby, like it raw with the shimmy, shimmy, yeah. Huh? Ain't sad, get like me. Never met a mother fresh like me. All these mothers wanna dress like me, but the chrome to your dome make you sweat like me. Cause I'm the killer, the coochie killer. Like how you figure, getting figures and keep it triller. She rolling switches for her chickens. I bought my, they getting pin up off the liquor. She love my licorice, I let her lick it. They say money, make act bigger rich. At least he'll figure it. She humping broads like I'm a humping dog. Turn a chick out, have a humping bars. Peace.
Love baby, got my raw raw. Yeah, I like the raw raw. Love baby, raw raw. Yeah, I like
Somebody real as you problem. Bring your girls to the crib, maybe we can solve. I know you love them when this beat is on. Make you think about all of the you've been leading on. Make me think about all of the rappers I've been feeding on. Got a feeling that's the same dudes that we speaking on. Oh, word, ain't heard my album, who you sleeping on? You should print the lyrics out and have a read along. Ain't it sing along unless you brought the weed along. And just drop down and get your eagle on. Or we can stay up at the stars and put the Beatles on. I'm talking about it's not up for discussion. I will pay to make it bigger. I don't pay for no reduction if it's coming from an. I don't know that I don't trust it. If you coming from my head, then get the blessing. Yes, Lord. I don't really say this often, but it's long. It ain't for the long talking. I think.
love baby, got my raw raw. Yeah, I like the raw raw. Love baby, got my raw raw. Yeah, I like the raw raw. Love baby, got my raw raw. Yeah, I like the raw raw.
Find somebody real as you problem. Bring your girls to the crib, maybe we can solve. Yeah, but it's the finale. A pep talk turned into a pep tally. Say she from the hood, but she live inside the valley. Now vacate in Atlanta, then she going back to Cali. Got your girl on my line, world on my line. The irony of at the same damn time. She eyeing me like it don't exist. Girl, I know you want it. Girl, I'm Kendrick Lamar, aka Benzes to me, just a car. That mean your friends is Stevie up to posse. My standards are pampered by 3 subs tomorrow. Kill them all, dead bodies in the hallway. Don't get involved, listen what the crystal ball say. Halle, Berry, holla, to you, holla, back, out to you. Peace.
Love baby, got my raw raw. Yeah, I like the raw raw. Love baby, got my raw raw. Yeah, I like the raw raw. Love baby, got my raw raw. Yeah, I like the raw raw.
Find somebody real as you problem. Bring your girls to the crib, maybe we can solve.
Listen, I played that because I saw, first of all, the first time, ain't the first time I played it, but when I played it, I hadn't played it in a minute. And both my brother Open was on it, and then Kim knew about it. I was like, see, that's what I'm talking about right there. They know some good music. So shout out to my brother on Grown Men Duty. Y'all, hey, my brother, he's old cutie, honey. He's old cutie. I tell y'all no lie. I get all the information. He's somewhat misbehaving, honey. But listen, y'all. This shit here is why. Oh, yeah. Right, right. I got you. I ain't forgot. Because I'm going to need some kind of calming down, Cookie. Because this man all hooked up in it. You know I am by my people. I am a protector. I had to check, my a part of my southern resource. See if we still had somebody at the CDC and at the hospital up down there through there in Georgia. The Emory or whatever damn hospitals with the research and all of that. Yeah. Like if I, need to go there for some reason. Make sure I have my people in place. I told you I got somebody at Equifax, ADP. Ooh, y'all don't have favorites. I ain't gonna tell you. I'm gonna let it be a surprise. I have to get my resources together. This shit, I gotta take my damn I take my damn blood pressure pill. Hold on. Okay. Now, who is this Ethiopia? Whatever. Yeah, we're gonna call her EH or something. Whatever these other people. Okay. This is RICO Enterprise. Mr. Jones recalls seeing defendants Grange visiting Mr. Combs' home in Miami, Florida, and Los Angeles, California. According to Mr. Jones, whenever defendant Grange visited Mr. Combs at his homes, it would be in the evening, and he and Mr. Combs would disappear for hours in Mr. Combs' bedroom. Lord have mercy. Y'all, is this looking like it's some you ain't pay me, I'ma pay your ass back and slander type shit? Or what y'all think about this? Hmm. Or you think we're gonna see us come across something that says he can substantiate by more than just what he has here of these photos? Because this is, I can present a photo of me and a dude, and I can allege that we've been having sex right before we took that photo, and when in fact he could have been at his church and I could have been at mine, right? But anytime you start seeing where somebody ain't pay you the money and stuff like that, a defense attorney will focus on that and be like, okay, maybe there's something, that they can, you know. But I'm wanting to see how clear were those photos of Stevie J and all them other little photos that they attached in here. How clear are those photos and stuff like that? Not that it's going to substantiate his claim that he was forced to do this and forced to do that and intimidated and all of that. I just want to know, is Stevie J running up into white guys' booties? That's what I want. Anyway. So it says defendant Grain sponsored and attended several Love album listening parties at Mr. Combs' home in Los Angeles. These parties were sponsored by defendants MR, LR, and UMG. As evidence above, these parties had sex workers and underage girls present. Now, UMG is Universal Musical Group. How are you going to say that they had the girls present? Maybe because it was one of its functions, or maybe UMG was maybe a sponsor of the function. They're trying to tie Dip to Puff Daddy and whatever alleged activity in some kind of way, right? To again ensure that he gets paid. Okay. During these parties, defendant Grange knew or should have known that Mr. Combs was drugging the attendees through lace bottles of the Leon tequila and Ciroc vodka. Oh, wait a minute. So defendant Grange should have known. Okay, who all's on this area? Okay. So they're going to say, they may be trying to say just because they're trying to establish why he would be liable. Somehow they're saying that this dude should have known. Well, are you going to say he should have known because he was there with the purchase of the lace bottles of tequila? Was he in on a conversation? Had he been in on this type of activities before, or what have you? Let's keep reading. Let's see how he makes these people liable. And let's flip over to a criminal side, right? So when you have a witness on the stand and you examine, right? First, you should establish that, just say if you have an eyewitness to something, right? A witness that's an eyewitness to a crime. First, you should establish that that person was there and that is qualified to say that they did see what happened. If not, then the other side will probably object for lack of foundation, right? Because um, you haven't demonstrated that this witness is qualified to say that they saw what they saw and that they were there. Okay. So with this, you're gonna have they're trying to, I mean, they're doing a good job of trying to tie all these people to these incidents to make them liable. So where there was no contract, they said it had implied, in fact, contract. So on and so forth. Everybody get the picture. All right, it says, it is no secret that Mr. Combs has specific bottles of alcohol designated for females and other bottles designated for his staff, his artists, and himself. The fact was detailed by former artists and bodyguards of Mr. Combs. Oh, Mr. Deal definitely gonna come out and be a part of this, I bet you, some kind of way. As a sponsor of these events, defendant Grange had a duty and obligation to ensure that sex workers and underage girls were not present and that Mr. Combs was not spiking the alcohol with date rape drugs. Now, it'd be interesting to find out how is this man, he gonna make this man liable or accountable or responsible for this, especially if this man ain't have no duty to do any of these things. Maybe he was just an attendant like the rest of them. Who knows? Let's keep reading. on YouTube channel, The Art of Dialogue. Oh Lord, that's I'm the dude from Houston. And it's an former bodyguard, Eugene. Lord, I talked Mr. Eugene up. Hold on for a minute. Did Mr. Eugene picture come up in this shit? Oh, yeah, there you go, right there. Okay. And former bodyguard Eugene Deal exposed Mr. Combs' pill mixing method used to spike cranberry juice and orange juice. According to Mr. Deal, Mr. Combs would place ecstasy and other date rape drugs in juices. Now, he done fucked up right there. Because we all know that Mr. Eugene Deal ain't reliable. So throw this out. And throw the Chris Brown stuff out too. Okay. Let's see. On YouTube, The Art of Dialogue, former artist Mark Kerr exposed Mr. Combs spiking bottles of Moet champagne in the VIP section of the nightclub. Mr. Combs would have a set of Moet champagne bottles for his artists and a set for women. See, all of this sounds like a good movie script. Okay? Ain't no black people doing all of this. It's black. Wait a minute, I saw something about some money down here. Okay, because we're gonna link this shit to money. Hold on. Okay. Let me see what's okay. TikTok is one of the most important short video platforms in the world. It has a significant impact on the spread of global music. Today it's believed that artists are paying more and more attention to producing music suitable for dissemination on TikTok. Due to failed contractual renewal negotiations between Universal and TikTok, a lot of music had to be removed from TikTok. This comes from the alleged lack of protection TikTok take to ensure UMG artists' rights and creativity is preserved as well as fair compensation. On the contrary, it has been alleged that the renewal failed due to UMG's own financial agenda and putting their interests first before the artist. This move has cost artists affected huge opportunities to further their growth and development within their art, as well as huge financial loss. However, UMG will still continue to profit off these artists, whether their music will be released back to TikTok or not. Yes, yeah, that's I read this because these defense attorneys can definitely explore the retaliation due to lack of payment or funding or something like that to this dude. Okay, so this writer has spoken with several former employees of Mr. Combs who witnessed defendant KK instruct her staff to lace Champagne de Leon and Ciroc liquor bottles with ecstasy and other illicit drugs. Mr. Mr. Jones recalls seeing defendant Albert Mariam visiting Mr. Combs' home in Miami, Florida, and Los Angeles. According to Mr. Jones, whenever defendant Hayward, whatever, visited Mr. Jones at his home, it would be in the evening, and she and Mr. Combs would disappear for hours in Mr. Combs' bedroom. According to Mr. Jones, defendant Haber, whatever, visited Mr. Combs at defendant CRS during Mr. Combs' right camp. Defendant Habersham sponsored and attended several Love album listening parties at Mr. Combs' home in Los Angeles, California. These parties were sponsored by defendant MR, LR, and UMG, As evidenced above, these parties had sex workers and underage girls present. During these parties, defendant Havishariam knew or should have known that Mr. Combs was drugging the attendees through lace bottles of the Leon tequila and Ciroc vodka. As the sponsor of these events, defendant Havishariam had a duty and an obligation to ensure that these sex workers and underage girls were not present and that Mr. Combs was not spiking the alcohol with the date rape drugs. The defendant, Christina Karams or something like that, is the Gillis, what her name is? Gillis Jelani, Jelani Maxwell, to Sean Combs, Jeffrey Epstein. According to Mr. Jones, during the 13 months he lived and traveled with Mr. Combs, he witnessed Mr. Combs display and distribute guns from his bedroom closet in Miami, Florida, Los Angeles, California, to questionable individuals dressed in all black. Now, come on, man. This sounds like a damn movie. What up, Mr. Blessing? Okay. It's some crazy. Why isn't this thing moving over? Okay. According to Mr. Jones, during the 13 months he lived and traveled with Mr. Combs, he witnessed defendant Karam openly order her assistants to keep Mr. Combs high off gummies and pills. Defendant Karam required all employees from the butler, the chef, to the housekeepers to walk around with a pouch or fanny pack filled with cocaine, GHB, ecstasy, marijuana, guns, 150 milligrams each, and 2C, a pink drug that is a combination of ecstasy and cocaine. Sound like a what's 2C? Tucci. What is that? It's important to defendant Karam to have Mr. Combs' drugs of choice immediately ready when he asks for it. Y'all, are y'all buying this stuff? Are y'all buying this stuff, y'all? Cause I mean, this is a good script. Like this is crazy. It was important to defendant Coram to have Mr. Combs' drug of trust immediately when he asked for it. Defendant Coram ordered sex workers and prostitutes for Mr. Combs. Defendant Coram ordered and distributed ecstasy, cocaine, GHB, ketamine, marijuana, and mushrooms to Mr. Combs and his celebrity guests who were present on his rented yacht and in his homes in LA, New York, and Miami. On multiple occasions, defendant Karam forced Mr. Jones to carry Mr. Combs' drugs pouch against his will. As the chief of staff, defendant Karam was instrumental in organizing and executing the RICO enterprise. Defendant Karam had the following individuals execute the following tasks for the RICO enterprise. Stevie J recruits sex workers and attends and participates in freak offs. You using the language from Ventura. Justin Combs solicit prostitutes, underage girls, and sex workers would engage in free calls. Brendan Paul works as Mr. Combs' mule. He acquires and distributes Mr. Combs' drugs and guns. Okay. Oh, footnotes. Y'all, whoever reading this, footnotes are going to be important. Okay, because it's giving us all the dirt. Okay, it says, okay, 18. Let me go back up to 18. What's 18? 18, 18. Definition, how feels. Okay, and it says we have a recording of this and we'll provide it to the court. Oh, okay, 19. What is 19? Stevie J recruits sex workers and attends and participates in free calls. We have a video of Mr. Combs, Stevie J, and Plaintiff Jones at a strip club. Mr. Combs is recording a video while coaching and training Plaintiff Jones how to recruit sex workers. Y'all know I get tired when I get excited. Y'all saying, hell no. Some of y'all get caught the R. Kelly. That's what's up. I guess they like to try because it looks cute. I'm just saying. Miss Angie, look at the words. He's using sex worker, underage girls, putting things in drinks, work up. Right, Joseph. I am. I'm paying attention. That's why I'm asking y'all. Like, what? Who is this now? Brendan Paul and Mr. Combs. Okay. Franklin Santella works alongside Brendan, while Brendan acquires and distributes Mr. Combs' drugs and guns. Frankie carries the money and pays for the guns and drugs. And that Adam no jumper. That's Adam no jumper. Ain't wait a minute. Hold on. Now maybe that ain't Adam no jumper. Wait a minute. Let me ask Mr. Blessing something. Mr. Blessing, did you see somewhere in the beginning the video of Stevie J, your boy Stevie J? Huh? Because I'm gonna start right here, and if you didn't see, not when it's not a video, but it's some still shot. Did you see your boy Stevie J? Because I can't wait to tell you about this. I'm waiting for your answer. Okay, I don't know. This dude, teller, looks like Adam no jumper. Mr. Blessing, I done got excited over this foolishness. Because this is some foolishness. I can't hardly talk. I get excited. When I get excited like that, I can't hardly talk. Or speak, rather. You have, hold on. I'm going to tell you what it is. You finna see it now, sir. I can't wait to show you this. Let me see what page I was on. 31. Okay. Go up there. Y'all, we catch him up? I think we should. This supposed to be Stevie J. Supposed to be having sex with some white dude in his butt. That's one photo, and this is another one. Yeah. Oh, let me tell you about this here. They also named, you saw a few weeks ago that the Adam guy had messed my, I had heard that a while ago. Oh yeah, you right, Kelly. Oh, check this out, Mr. Bless. So I'm married to Chris Brown. I know that he don't, right? But he, so, but listen, they said that Meek Mills, what they said Meek Mills was doing, hold on, was Meek Mills involved in the gay stuff? Hold on, let me see what they said, but Meek Mill was doing. I don't lie on nobody. They said Mr. Combs informed Mr. Jones that he had engaged in sexual intercourse with Meek Mills, Usher, and whoever number 7 is. Okay. They said Chris Brown, underage girl. Yeah, that's what they said. Mm-hmm. How many pages? I can. Where am my phone? Yeah. Oh, they got the boy Cuba Gooding Jr. here too. You're asking? Are you saying that, Mr. Blessed? Look at your boy Cuba Gooding Jr. I'm trying to catch up. Since you always what was that right there? Baby, they got all the little pictures. Look at your boy. Yeah, that's your boy Cuba. And now look out. Now, y'all, Club Blue. Answer me this. Do this look like Cuba Gooden is forcibly touching Mr. Jones in the way that you would think forcibly touching means? Now, this is how they're going to try to swing it. Meaning, like, by him affixing his, not affixing, but by him placing his arms around him, that's like, that's force because you're laying it on his shoulder instead of force meaning I'm trying to force myself upon you and you don't want me on you. Okay. But see, even if you try to go that route, that smile on your face doesn't suggest that you don't want his arm around you. Either way that you try to use our lawyer tricky ways of working shit for in order to support your story, their story rather, I think it won't work. Because if you try to go with force, meaning you're not um saying you don't want his arm around you, inside you might be saying it, but here's the thing: if you didn't have no expression on your face, you could probably go at that description of force. but this person has a smile on his face. So that ain't gonna work. And you're not showing where you are pushing him off, pushing Cuba Gooding Jr. away from you. That's not happening either. Unless, wait a minute, let's see what he's doing with that arm. Come on, y'all. We gotta help. Hey, Keller. Keller, you said I can switch it. I told you if every time came, but we have to defend Chris Brown, not a problem. Diddy been running up in them Negroes. Damn, shaking my head. I don't. Chris Brown did anything wrong. Yes, man. They saying that Chris Brown, thus far, they saying that Chris Brown was with underage girls. He's not named in the act, right? But this dude, somebody, is throwing his hot mouth, throwing them all up under the bus with videos, photos, everything. He gotta go for me asking for 4 point. Who do Joseph Hayes? Yeah, they ain't saying he get down like that yet, but they said the usher did. And could you believe it? Meek Mill, honey. Meek Mill. Okay, now who is this? Mo Bond, Thanksgiving 2022, when Mr. Combs offered Mr. Jones cocaine. Who was Mo Bond? Yeah, yeah, blessed. That was him on those. That was allegedly him on those little photos I showed. That was him supposed to be having sex with a white guy. This right here done knocked me out. This claim has knocked me out. And this stuff was happening around 2022 and 2023 and stuff like that. So it's still, the statute of limitation is still running. It won't be time barred if they pursued a criminal act, right? My thing is, if they had enough for that, they probably want to get the money up front first and then go and then, pursue a criminal action. But it's crazy. You would see Meek Mill like that? I can't. No. I know Nikki somewhere having all kind of panic attacks because people don't know how status works. It's on your social credit. The actions that Meek Mill does, even though they ain't together no more, it goes on her credit as an inquiry. Hey, as a soft pull. Yeah, that's crazy. Yeah. This is what I was let me see. Who else we have? Damn, this thing keeps clicking off. I'm serious. This thing, listen, y'all. I gave y'all a breakdown a couple times on how social credit works. Yes, I told you that I got friends right now probably wondering why they can't get back in they can't get in VIP no more. They can't get tickets, pick the tickets up at will call. They got to pay for stuff when they go out. They don't know it's me. Yeah. They don't even know. Told y'all how it work. Anybody, like just say with Mr. Walker, okay? Anybody that he was with prior to me and after me goes on my social credit and vice versa. Okay? I mean, like when he had one, like that one baby mama. He had two baby mamas. But he the one baby mama. She you know, she wasn't half bad. But she still drug my credit. I was like, God damn, but the rest of the people's okay. He had one, the other baby mama, she was, supervisor down there at the light bill company. Okay. She was okay. Hey, I'm trying to tell you, y'all just don't know about how these circles work. I'm trying to tell you. Gotta give y'all a crash course now. Everything ain't about the ghetto and being ghetto fabulous and ghetto fine. If you out there and stepping with the big dogs and stuff, well, there's a price to pay. Price to pay. I ain't never date nobody from the hood. Mm-mm. Even though I was in the hood for 14 years, I went and got mine out from like where I stay at now, like from the beach and stuff like that. No ghetto. Nope. No hood. No people with goals in their mouth. None of that. Tattoo people. None of that. No braids. They had it like Jay Z. None of that. Can't do none of that. No dread folks. Now let's see. Okay. I want to get to some good stuff. I'm gonna skip through it. I'm gonna come back and do a more comprehensive, but I want to get to who is Mr. Combs is allowed to wreak havoc. I want to talk about. Okay, first. Okay, let's read about how they're trying to lay out this RICO or let's see. First cause of action: conduct and con, conduct and participate in a RICO enterprise through a pattern of racketeering activity, violation of Racketeer Influence and Corrupt Organization Act, codified at USC Section 1962A, C through D, against defendants Lucian Charles Grange, Ethiopia, Hab Tamarian, Sean Combs, Justin Combs, Christina Haram, Combs Global, Motown. Oh Lord, they got Motown Records in there. What? Love Records and Universal Music. Mr. Jones incorporates by reference all preceding paragraphs and realleges them as if set forth herein. As respondents, superior defendant Lucian Charles Grange, all them people. Okay. Defendants are individuals and or entities within the meaning of person as defined in 18 U.S.C. section 1961(3). Because each is capable of holding and does hold a legal or beneficial interest in property. The association is composed of Lucian, Charles Grange, and all those people, okay? And I told you right here where it says the John and Jane Does, 1 through 10, that simply means that at a later date, they're going to come in and give you the names and whatever, right? So those are names. When you see ABC corporations 1 through 10, that means those are going to be companies that are going to later come in and fill out the 1 through 10. All right. We are familiar with section 1962A. All right, in a RICO. It says section 1962A makes it unlawful for any person who has received any income derived directly or indirectly from a pattern of racketeering activity or through a collection of an unlawful debt in which such person has participated as a principal within the meaning of section 2, title 18 USC, to use or invest directly or indirectly any part of such income or the proceeds of such income in the acquisition of any interest in or the establishment or operation of any enterprise which is engaged in or the activities of which affect interstate or foreign commerce. 18 U.S.C. section 1962A. Section 1962C makes it unlawful for any person employed by or associated with any enterprise engaged in or the activities of which affect interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprise affairs through a pattern of racketeering activity, 18 U.S.C. section 1962C. So, okay, y'all, earlier when I was telling you guys how they will make people and companies responsible, liable, accountable. In other words, to make sure somebody with enough money and or access will be listed on this claim that can pay in the event they win. Okay? They do that by, although you may not be directly employed by, just say, Universal Music Group, right? The activities that you perform, either on behalf of them or in conjunction with them or in the presence of them or what have you, you don't have to be a skillful lawyer, but a lawyer good enough can make the judge infer that, hey, you are an employee of. Remember, I have pointed that out on several different civil suits that we have been covered, right? Just like they tried to make, I think J-Bo tried to make Tasha K a somehow I think that's how it went. Somebody that's associated in association with that particular lawsuit, an employee, not because they actually physically work for them or they have, a application or whatever. They receive some kind of benefit. They perform some kind of duty, something like that. That an attorney could sit up there and make an argument to say, hey, that person works for that particular company, although not as a traditional employee. However, they qualify as a non-traditional employee by either the way they get paid, the way they conduct business, so on and so forth. Okay, and it's just a trick, not really a trick, but a a way to make sure that somebody with enough money is held reliable, responsible to, pay if they win. Don't get sloppy with the word. Did it got money? But at the end of the day, if they all would have stood up against the R. Kelly documentary and the setup, instead of being closed mouth when it comes to standing up for the industry, they wouldn't be here, knowing that all of them have participated in wild parties and wild lifestyle. Okay, Mr. Blessed coming on through with the knowledge and the wisdom as an old cat could. Only you could do that because you're an old cat. Well, yeah, I get what you're saying. Yeah. And see, not that I'm a supporter, right? Okay, of any of either side, okay? But when I was speaking about the type of support that could have been given, that, certain things that could have been carried out, seen through, somebody could have taken the lead on or whatever. No, you Negroes rather set up, stay down here and argue and bicker and do stuff that didn't net nothing but more confusion, right? See, when an industry is being attacked, you have to attack that industry, right? And what I mean by that is like when they had petitions going on out here, it saw little to no um, what I want to say, like participation, right? It didn't make it to where it needed to go, even with the names and stuff that were on it. They make these laws and they amend these laws based on evolution. Although it doesn't seem like it ever matches up because the law moves very slow. But based on changes and they made laws to reflect where we are today, right? But with that being said, no law can be oppressive. No law could infringe upon someone's right. Okay? Um, Legal actions like ex post facto, right? It's always it. They have a bunch of challenge against ex post facto, as you heard Miss Bonjean. She wasn't calling what happened in the case that she was arguing for with or arguments in the objections she was making. She wasn't saying that it would violate ex post factos, but she was more challenging the language, right? That it was sports speaking rather than retroactively speaking. Well, we know that what caught Mr. Kelly up, for the most part, was language in the law that was retroactive, okay? That had a look back period and all of that. So that's why it was able to catch the the um, the, the crimes that they alleged he did. He violated, the crimes that they alleged he did back in the day, right? Now, the problem with that most people will consider ex post factos unconstitutional is that when you have behavior that wasn't against the law 15 years ago, all of a sudden is against the law now. And worse than that, it doesn't start just as of like 2023. It applies retroactively. Half, just about every defense attorney have a problem with that. But half of the attorneys all over has a problem, no matter what side. Because just think about it like this. If R. Kelly would have been prosecuted, or if it's the same thing that happened to him, but then, like back in what 2020, whenever he got what 2021, 2022, or whatever, whenever he was found guilty. Just say if he had stood had gotten indicted for those charges or went to trial for those charges way back then when it happened, when the statute of limitation was enforced, right? 9 out of 10 times he would have only been charged at the state level. He would have been done his time and got out. He'd have been out by now for a long time, and he would have been, living his life. The penalty affix would have been different. Wouldn't have been on 30 years and all of that way back then. Okay? So you see where that ex post facto shit, while it is good for some crimes, but with the legal system, regardless if you commit a crime or not, you're supposed to have justice. Okay, justice on both sides. Justice for both sides, no injustice for either side. Okay, you can't have injustice. You got to have justice on both sides. I know I'm all over the place, but I'm trying to. And me and Mo was talking about this earlier today. Because she said she do the same thing when she's trying to explain it, but she's trying to take out the professional words and use the words in which you guys can understand to tie it all together for it to make sense. Okay, that's hard sometimes when you're trying to find the right words, because sometimes when you change the words, it changes the meaning. I'm trying not to change the meaning and make sure you understand it, right? But y'all kind of get the gist of what I'm saying. If he was held accountable for whatever they allege he did back in the day, okay, he'd have been out by now. Which is one way to look at it. His crime definitely wouldn't have been as harsh as it is today. And may just say they just say whatever crime they allege he did in 1991. Most time the statute of limitations to bring most crimes is what, between 2 to 5 years, right? With financial crimes, it's like 10 years. Well, just say if he committed a crime in 1991, they didn't discover it until 1997. At that point, it was too late. It was time barred. So it was too late to bring any type of action against him. So he wouldn't have even done any time anyway, if y'all understand what I'm saying. Because that 2008 trial was based on something he did in, was it 2020? What, 2002 or something like that? Something like that. So when it comes to ex post facto sin and shit like that, the defense, they make good points. If you look at some of the case law with regards to, they make good, and then you might say, hey, okay, it does even out, because also where ex post facto can criminalize crime, actions that weren't criminalized before, it also decriminalizes, right? To make it even. But we're talking about only the part that places that deals with the the restriction harm to someone that just 30 years later, boom, being hit with a crime. Now you're injuring that person. You're causing harm to them under the Constitution. You're not supposed to injure or bring harm to no one. That's also considered up under double jeopardy. That's the language up under double jeopardy. That's why you don't um you don't put someone under double jeopardy, because it causes harm to them. So you can't cause harm to nobody. You can't oppress people. All this is under the statute, and I'm sorry, under the Constitution. I'm getting sleepy, y'all. Under the Constitution. Let me wake up. Let me wake up. Okay, wake up. Man. Here we go. I know I'm probably confusing y'all, but if you understand what I'm saying, it's a lot of language under the law that does exactly what they say they're preventing, what they are preventing by when they constructed the law in the first place. Maybe on one part, they were like, yeah, you get some relief, but a couple paragraph down, you see where you're being injured. Okay. Now I can't believe I'm using the word injured, but you guys, I don't mean to use that word when I mean go to jail, being detained, okay, losing something. So you're losing your liberty. So that's what I mean, being harmed. Okay, so that's what I mean when I say the word harm. I mean losing something, either like by being detained, or you understand what I'm saying? I'm so sleepy. Sleepy, y'all. I'm trying, Mr. Blessed. You new Negro on this list got nothing. But yes, exactly. But I was trying to expand on your the point you made. I should have just left that point you made alone. Well, I'm sleepy as hell. But I'm serious. When you know you aren't cross-sided and you seeing shit that's in doubles and shit, you trying to tell you. But what I was saying is that if they would have put together a comprehensive fight against the law that seems to be the parts that seems to be unfair, meaning you don't focus on someone's innocence or guilt. Don't open up Pandora's box. Fuck all of that. Don't question it. Focus on the fight that says, hey, that's unfair. Which, as you see, that's what Jennifer Bonjean is doing at the appellate level. Another word for that is to focus on those things that are unconstitutional. And when I let you guys listen to that phone call between me and my colleague, the guy I went to school with, that's when he was explaining. Focus on those things that are unconstitutional. That's what you do for appeals. Things that would be constitutional is like when you focus on, when you see like sufficiency of the evidence. Okay. You want to focus on things that you would consider that has been done to your client that would be deemed unconstitutional, because under the Constitution, that's where you are guaranteed your rights. Your client is guaranteed certain rights. And if any errors occurred at the lower level that cost your client his or her rights, then what you see took place the other day with the oral arguments is generally what's going to wind up happening. Instead of her filing her brief and getting a hard, flat no, you see, she was able to get 2 oral arguments scheduled. You know, maybe they could have kept on with the protest to make sure, and it didn't have to be an overwhelming amount of people that came out. It's the message that counted. It's making sure that you strike in front of those places that matter, that get covered. You understand what I'm saying? So it was an excellent idea when Miss Sharon said, hey, march down there and watch. You have to get this stuff in front of lawmakers or in front of those groups. And also you got to merge in front of merge into those groups that have the ear of people that make decisions or know somebody that makes decisions. You see what those small groups do, like let's take for instance, like the people that's against abortion. You see they ass blend down there with the damn Black Lives Matter people. Those are the opportunities that you have to exploit. You want something done, and we the little people. We can't get nothing done. And that's when you pay attention, when you see like Black Lives Matter and some of those large special interest groups be out there, you look around, you see gay pride and this type of whatever going on. Yeah. Because they know they are showing up to get their matter in front of somebody. Their rights heard, along with, Black Lives Matter and stuff like that. Oh, y'all mad. Y'all rather sit here and fight and all this type of stuff. And and I mean, and the blueprint was already made. That's why the people that were against R. Kelly, that's why they kept winning, because they had a format, a formula. Get the shows count. Get them put off the label, off the radio. This, that, third. To pretty much, she got to be out of sight, out of mind. They were hoping, right? All you had to do is take that same blueprint, get him back on the radio. Get his, if he can't be there for the concert, hell, have those big listening parties and shit, and all that type of stuff. Be down there in record numbers when he go to court. That type of shit. Undo what has already been done. Right, blessing. Right. They get in those big groups so they can hit, so their voice can be heard. They start whisper campaigns. That's what another form of protest is called whisper campaign. Starting big presence about restoring rights and things of that nature, whatever, online, through social media, all of that. It didn't need all that money. You had people. I was amazed about when that girl, I think it was Nobody's Anything, was saying how people wasn't really supporting the online, whatever she had going on. Like what? Like they don't support that. Like I don't know where those petitions got delivered that Bitten Fire and some other people was handling. I don't know where they got delivered, but you have to, and fortunately or unfortunately, you have to be dedicated to that stuff. It don't just you can't tire out. People got to stay galvanized. You got to continue to push that type of stuff. But hey, let me find some other stuff. Let me find some good stuff. Y'all know I'm looking for anything dealing with my boy. So they're trying to establish a RICO enterprise. So here, pretty much, they are going to establish what exactly constitute a RICO enterprise, as with all claims of RICO enterprise, both civil or criminal. They have to establish what makes it a RICO enterprise. What pattern of behavior? Um, this is interesting. Y'all remember about the Shine Post shooting. Listen to this. Upon information and belief, this RICO enterprise has existed for at least 20 years. Look at they going back, dating back to the 1999 nightclub shooting in NYC, when Mr. Combs required his then girlfriend Jennifer Lopez to transport his illegal firearm into the NYC nightclub. Now remember, for a RICO, you need two predicate acts to occur within 10 years, right? Says Mr. Combs forced his then artist Shine to assume responsibility for the shooting of several individuals. Mr. Combs used his power, money, and influence to bribe jurors and witnesses, such as the friend of the shooting victim, Tina Rubin, who reported to law enforcement that she saw Mr. Combs and not Shine pull the trigger and shoot her friend in the face. Tina Rubin later testified at Mr. Combs' criminal trial that she was trying that she was tying her shoe and may not have seen who shot the gun. She later confessed that Mr. Combs paid her. What? Then you got the RICO enterprise that included the Cassie Ventura. Remember, she just sued him. Um, the RICO enterprise continued from September 2022 to present day. Oh wow! So what? The enterprise characterized by the defendants a pattern of false representations and omissions made by defendants Sean Combs, Justin Combs, Christina Coram, and other current and former members of the defendants, associates, and staff, and defendants artists, creative musicians, and producers. Okay, there go the money. Additionally, Mr. Combs used the prospects of winning Grammy Awards, purchasing 20 million dollar homes, participating in future projects, making 250 grand cash payments. Oh wow. Mm-mm-mm-mm. I'm trying to read some good stuff. Intentionally devising participating schemes to defraud plaintiffs out of money in reliance on the male defendant committed these acts with the intent to defraud plaintiff Jones and the artists, creators, musicians, and producers. Um, defendant cannot have furthered their fraud without the use of mail. Oh yeah, they hooking them up. My goodness. Uh, 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 uh. I'm trying to see if he draws some more people names. Mr. Jones incorporates by reference all proceedings, paragraphs related to this is where it says sexual assault and sexual harassment against Mr. Combs. This is by the guy, Mr. Jones. But did y'all see how they slowly but surely introducing like a male in these claims as you know when it came to P. Diddy, remember they kind of alleged that it was a male, but not that not he wasn't having any type of relationship with P Diddy. And then the next known one we really read about was with him and Aaron Hall forcing the girl. So there was a guy around in that, right? And now you're saying where they are alleging that P. Diddy was with this guy, Mr. Jones, in a sexual kind of way. And they group stick together and not after each other's throats every day. They be there for the greater general right, which should have been illegal. Not complete that time. Right, your point, right. Third cause of action, California's bystander negligence infliction of emotional distress against Mr. Combs and defendant Justin Combs. Yeah, Justin Combs. This is crazy. You know what? fellas, you know what? I'm always leery of how you guys are with y'all son. You know, if your son get have sex at 14, you be like, atta boy, how y'all be saying or whatever. Y'all make me nervous. It's always made me nervous when it came to men having sons and kind of well they you know them being raped. Oh, I'm sleeping. Okay, let's see. The emotional distress is involved about the shooting, about when Mr. Jones said he was in the bathroom and he heard the gun go off. This other, the fourth cause of action is the sexual assault against Jane Doe #1, Young Miami's cousin. Now it's some girl walking around in Miami and everybody knowing she in this lawsuit. But Joseph Hayes, bless it. Do y'all see how this dude stuck around? He didn't call the cops. Apparently, he didn't want to do what they were making him do. All of that. I'm trying to see, when did he make first police report with regards to all this stuff that P. Diddy was making him do. Let's see. Ooh. Mr. Jones incorporates reference to our proceedings paragraphs related. Here comes Mr. Jones was sexually assaulted by Cuba Gooding Jr. Sexually assaulted by Cuba Gooding Jr. on a yacht rented by Mr. Combs in the U.S. Virgin Islands in January 2023. Boy, bye. Mr. Combs was present while Mr. Jones was being assaulted by Cuba Gooding Jr. Mr. Jones was legally on the premises as a guest and invitee of Mr. Combs. Cuba Gooding Jr. was legally on the premises as a guest and invitee of Mr. Combs. Mr. Combs owned, through renting, the premises and had dominion and control over the premises where Mr. Jones was harmed. Mr. Combs had dominion and control over the actions of Cuba Gooding Jr. and failed to step in and stop Cuba from sexually assaulting him. Since I told y'all early on, right, this guy was holding these people liable, responsible for security, for this, for that, whatever, to make sure he gets paid. As the owner of the property, Mr. Combs had a duty to protect Mr. Jones from the harm he suffered at the hands of Cuba Gooding Jr. And that's how they tie you all into this, that they want to make sure they get paid. It's the seventh cause of action, Trafficking and Victims Protection Act. Mr. Jones, okay, defendants, Mr. Jones. This is about recruiting the the sex workers and others who are up under the age of 17. What's TVPA? Must be brought up. I think it's that. Okay, the Trafficking and Victims Protection Act. So that's TVPA. So, boy, and this is where it gets kind of bad. Under this act, there's going to be some elements. Will the elements be, well, here are the elements right here. Some of it. Defendant Sean Combs, Justin Combs, Christina knowingly and intentionally participated in, perpetrated, assisted, supported, facilitated a sex trafficking venture that was in and affecting interstate and foreign commerce together and with others in violation of 18 U.S.C. section 1591A1. Okay, so those are elements that need to be proven. When you see these acts, remember that act that came out that allowed Diddy to get sued by Cassie and some of these other people? Those acts have elements that need to be substantiated. And anytime you see the word knowingly and intentionally, that means that the prosecutor has to prove intent. So that's another element they have to prove on in order to substantiate their claim. Okay. I'm just going through here. Okay, the California premise liability, inadequate or negligent security. Oh, okay. Okay. So this deals with the safety and security. I went over that several times. Okay. I told you early on, I said it seems like he's going to try to make P. Diddy responsible for security in several different areas of this particular claim, right? And that's what he did. I mean, it's a pretty straightforward claim. All right. Remember, I was just telling you when I was sleeping how we as Americans are supposed to be protected from harm and things of that nature. Harm can be actual harm and injury, what you think. Harm can also be being detained. Okay? Listen. In this case, listen to this. Says as a proximate result of negligence, right? That's causation, right? The cause and effect, causation. And the test for causation under the law is the but for test. But for your actions, this wouldn't have happened. Okay. So, as a proximate result of the negligence of defendant and each of them, plaintiff was hurt and injured in his health, strength, and activity, sustaining injuries to their nervous system and person, all of which injuries have been caused and continue to cause plaintiff great mental, physical, and nervous pain and suffering. As a result of such injuries, plaintiff have suffered general damages in the amount according to proof. Okay. So somewhere in here, he's probably suing for compensatory damage, which is actual damages, maybe punitive, but we'll see. So it says general damages according to proof. So general damages is what they can show proof of, like they were damaged or lost or what have you. So it's a wide range. For actual medical expenses incurred, for future medical expenses according to proof. So that's they're gonna have to prove some kind of estimation, right? Like just say if this person was going to see a psychiatrist in the future, they have to have some kind of estimate bill or estimate medical, like for medicine or something like that. It says for loss of earnings, that's self-explanatory. For interest, according to the law, so that's interest bearing, like just like in a bank. If you put your money in the bank, interest bearing, right? Says for cost of suit incurred herein, and for such other and and further relief as the court may deem just and proper. Okay, so that's leaving it open for the court to maybe to assess some kind of punitive damage or some other cost that the court that's within the court's limits, right? That's what it's leaving it open to do. You can specify, or you can specify, you can leave it open, you can specify and leave it open. Okay. What is this? Is this another? Okay, it says it's aiding and abetting and inducing a sex trafficking venture in violation of the Trafficking Victims Protection Act. So it is the same TVPA Act. Okay, that they allege the Universal Music Group, amongst other entities in here. And it says Mr. Combs co-conspirators knowingly benefiting from coercive sex trafficking. Okay, they have to prove that. So that's the element they have to prove. Um, Financially benefiting. No. Let me see what else. When I tell you they laid this out, my God. Boy, there they go with Jane Doe, Young Miami's cousin. Let me see, they got some other good stuff in here. They got all of this stuff is emotional. All of this stuff is uh, uh, emotional distress. Emotional distress. Okay, this is knowing beneficiary in a sex trafficking venture in violation of the same act. And I told y'all when y'all see two of the little squigglies, one means one section, two means sections. So that's how you read that. So you say 18 USC sections 1591A2, 1590, and 1595. So those are two more sections. Let me see. Y'all know I'm trying to dig for some more names, honey. This is pretty much religion, same stuff. Oh, wait a minute. Somebody was signing some NDAs. Okay, it's constructive knowledge extended to the names of Combs' victims because Combs and his associates knew the names of the victims. Mr. Combs had hundreds of cameras in his homes in LA, New York, Miami. Mr. Combs required the sex workers and underage girls to sign NDAs prior entering his parties and prior to being drugged and sex trafficked at these parties. Do you have proof of this, sir? Hold on. What did he say? Let me see if he got proof. Free my man, Chris. Hold on. Okay, by virtue of these knowing and intentional violations of 18 USC sections 1591, A2, 1595, defendants, blah, 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 sustain reasonable attorney fees. Okay. It doesn't say you have any proof. What is y'all talking about in here? Y'all going to sleep on me? Keller, why is you saying stuff like that? Keller, I can't with you. Um, I thought I put the link in here for my stay up crew. Stay up crew, y'all don't be. Okay, hold on. I still ain't got the nature boy. Good night, Mr. Blessed. Hold on. I had to go back around now. Hold on for a minute. Okay, hold on. I'm coming. Hold on. Trying to get back running now. Hello, Miss Cookie. Hello. Hey,
Hi,
Miss
Miss
Cookie.
Auntie. You wait till it's half past the monkey's ass to open up your door. How are you?
Miss Cookie.
Yes. Can you hear me?
Y'all hear
Can
me?
you hear? Can you hear me?
I don't hear you.
I'm not muted.
Hold on. Let me see. What? I can't hear you.
Did you mute me? You want me to go out and come back in? Oh, you can't hear me. Go out and come back in?
Okay, wait a minute. I can hear. Wait a minute. Why I can't hear you from my TV?
I don't know.
No, you fine. Hold on. Why I can't hear you? No, you need to stay right there so I can adjust my settings so I can find out what's going on.
Hello, chat. Can the
Say
chat
something
hear
now.
me? Let me see if I. Let me.
You good. It was me. I hear you. Can you hear me?
You're kind of low, but I can hear you. It could be that I have my volume up. I mean down. But let me check it.
Okay. Okay, hold on. Let me make sure I can hear myself. Hold on.
Oh,
Can I hear
so how
me?
are you?
Sure I can hear myself. Hold on. Can I hear me?
So how are you?
Okay. Why you left? I heard you. You was good. Why you left? I heard you. You was good.
Can you hear me
Okay.
now?
Yeah, I heard you before you left. I was telling you, I heard you. It
Hit
was
the
me.
button by mistake, Miss Angie. You know how I do. I double
Oh,
click. Well, how are
okay. I
you?
was like, let me make sure. Okay. Now, what's going on? You can hear me still?
Yes, yes, ma'am. Can you
You
hear
can.
me?
All right.
Yeah.
Yeah, I can hear you.
Sorry about
Yes,
Chris
ma'am. What's going on?
Brown. Nothing. Been
I
missing
know,
you.
and uh, that messed me up. How I'm supposed to marry him now?
Now, all this time you've been gone, you should have had this straightened out.
I know. I miss my Chris. I know. I got to keep looking on his Instagram, whatever, because I know he's gonna address it.
So,
He gonna be like,
what
I don't
what
know
drop
about you.
dropped today? What you read today? That came out today?
This actually yesterday. This came out yesterday.
Okay.
No, yesterday.
Yeah, I haven't been on YouTube for a couple of days. So I've been trying to give my brain a break from all this
Like
stuff.
Monday came out on Monday.
I know when this
Mm,
thing first came out with Diddy and what's her
I
name?
don't know.
Casey. I was on the fence with it a little bit because we know Hollywood is Holly weird. And
What you saying?
I had this whole thing about, people being with somebody
Yeah.
and then when things end, now you want to come out with all this dirt. So I always call them willing participants. I don't care what age you are. If you lied about your age, you was willing participant. If you're older, you know better, you ain't stupid. You were in that situation for a reason. So I'm not saying if it's a minor and, a real true minor, but if you lied about your age and you was a minor, I put you in that category of willing participant. So when I first heard about Diddy, I was on the same fence of what I was with, Kels. People coming out of Woodward, with these accusations after you've been with this man for so many years, after you done lived that glamorous life, and now things is over, and now, oh, he did this and he did that. Y'all had freaky parties, you had freaky parties. Don't care how many people joined in. You were okay with it for how many years? So I really don't want to hear about it. But I still kind of feel that way, but I'm looking at it a little bit different. Not when it comes to Chris Brown, but then I guess all of them, because if they are guilty, if like I said, if I wasn't there, everybody knew what they were doing. I don't know how illegal this is. This, the civil thing. It's about money, so it's just about money. But I keep asking people this. I've been saying this for years and nobody seems to know what I'm talking about. When Epstein first got arrested, somewhere around a couple of weeks after he got arrested, CNN posted this list of names. It was mostly a whole bunch of entertainers, but it also was Donald Trump, Jay-Z. It was a list of people, and they showed it for a little bit, but not long, and they went through these names real quickly. I did not see R. Kelly's name. Now they talk about this list, and it's mainly talking about politicians. You know what I mean? So, but I believe there's a book that this man had of people doing kinky sex stuff and maybe some illegal stuff. But because Kels was known for his way back past, they knew they could get us to go against him because there were people still feeling like he was guilty from 2008 because of the P tape, because of Aaliyah. So they put him as a trial. Let's see how bad or how good we can get in the minds of these black people to turn against each other. And it worked. And once they seen that it could work, then what happened? Right after Cal, you had, I think they tried to go after Snoop Dogg. They tried to go after, what's that rap? What's his name? Oh, Jesus. Trey Songz. And it was a couple of more people, but it died down. And then they just focused on Kels. Now they got what they want, and now what do you hear? You hear about those rappers, how they was going to, use their lyrics against them. And now we're where we're at now. And what are they doing? RICO, Mann Act, all the things that they tested with Kels and passed. Now we got them. So anybody they want to get out of the way for whatever reason, they're gonna do it. They can't kill you like Michael Jackson. They'll dope you up like Prince. You know what I mean? Or they say that you're crazy like Kanye West. But if not, and we ain't got those things, we got sex. Because everybody knows everybody's doing that kinky shit in Hollywood. Weird. So, what do you got? All our black men's going to jail or getting their money taken from them. Now, what you gonna do? What you gonna say? I don't feel sorry for them. Did you hear all that?
Yeah, I get what you're saying. Yeah, I heard you. But and I can see why why people would feel that way.
Mm-hmm.
But here's the thing, like when they change the law, you
Yeah,
have to go by the you know.
but just like we have the law supposed to be right, we have the law of our people who we believe in the innocent. Like you don't want to believe about Chris, but I'm pretty sure if the evidence against you, you're gonna feel the same way that you do with anybody. You look at the law, but it breaks your heart to know that what you're involved in this. But everybody is, Miss Angie. They all are. Will we have ever thought years ago that Jada Pickett and Will Smith was involved in stuff like that, or what's his name and his wife? Um, oh Jesus, what's his Ti and what's his wife's name? Tiny. We're hearing
Mm-hmm.
about all these couples. I think was it Gabrielle Union and her husband Damien was supposed to be involved in some kind of mess like this. So
Dwayne Wade, they said something, but nothing ever came out on paper.
right, but I bet you it will. Give it a couple of years. It's gonna brew back up. You know what I mean?
But it's
Because
a
they've been
mess,
after Chris
right?
Brown for years, ever since Rihanna, right? We already know they was after Kels ever since Aaliyah and the infamous tape. So when they get tired of you after you did and made their money, or you trying to do too much, you trying to get too much power, you trying to get too much of that generational wealth for your children and your family. Oh no, no, no! This nigga think he really about something. Because I feel like that's the same thing that happened with Bill Cosby. What was he trying to buy? CBS, and then all of a sudden all these women, blah, 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 blah. But people had said this about him years ago. A little bit. It was a little bit of talk about him. So there's always a little bit of talk, and they just let it slide because you're making the money. But as soon as you get too big and you try to own something they don't want you to own, or you try to claim something that belongs to you, what do? They come up with these accusations. And
Mm-hmm.
what can you do about it? If you don't stick together, you're all going to tumble down and fall. Everybody laughed, had something smart to say, had their little comment to make, to the media about Kel, wanted to take their names off of songs he wrote for. Like, really? You can't erase history. Keep your mouth shut or speak up, but you can't erase
Mm-hmm.
history. Lady
Right.
Gaga, Celine Dion, all those people, and even the blacks, the whites, everybody. Oh, you ain't touching my money. I'm not gonna get blackballed. Oh no, no, no. Even if it was about, even if he was guilty, but speak on what you know. But y'all made it seem worse than it was. Y'all act like y'all believed everything. Y'all act like y'all were there seeing everything. Well, then y'all should be in jail with them. Because if you seen something, say nothing. What are you? Co-conspirator? Accessory to a crime?
Mm-hmm.
But yet, like we've been yelling, one man ain't no enterprise. Kel's the only one that's in jail.
Yeah.
So if you're gonna get one, get all. If you're saying it's an enterprise and all these people were involved in doing these crimes, then all should be charged and face a jury of their mates and be found guilty or not guilty. So I like Chris Brown. I like Cuba Jr. You know, I think it was years ago when they saying that Terrence Howard was a womanizer. So give it time. Let him start popping up in movies and stuff.
Mm-hmm.
His stuff gonna come back up. It's just crazy. Um, how they got rid of even Don Lemon. I don't believe that mess about he at a party. He's gay. Yeah, he's gay. He's engaged. I don't think he had got
Mm-hmm.
married yet, or maybe he did. I think he did. And he's in a bar. He's so drunk. He's gonna put his hand down a man's pants. Like, what kind of people we got in our world today that you could just do anything to people and they just stand and you're in a bar and somebody can just come and grab and put their hands down your pants, and you just stand there like, I'm so shocked. Like, did he do that? You're not gonna jump back. You're not gonna say, man, what you doing? You ain't gonna punch him. I don't care if he is gay,
Mm-hmm.
especially if I ain't gay. It don't make sense, Miss Angie. It just don't make sense. And for us people, us black people, like I said, if you're guilty of a crime, yes, you
It
should
don't.
do the time.
It don't.
But we are so fast to turn our back on each other for anything and everything. It ain't just the rich people that do it. Normal people like us, we do the same thing to each other. And we wonder why we don't get nowhere. It's just crazy. It's crazy.
Mm-hmm.
What is DB talking about?
Girl, listen, I'm so
Hmm? You said you're through? Miss Angie, are you going to sleep
cool.
on me? Well, somebody better come up here so I can have a conversation. Can you hear me,
What
DB?
are you talking about? No, I oh, you talking,
You going to sleep on me again?
girl. Who, me?
Yes.
Not not me. I'm trying to still look for this case with this dude named um Cash Out.
Who? Who you say?
Cash Out, a rapper named Cash Out.
Cash out.
Cash Out. I don't know. His name, he got four names. John
What he
somebody.
supposedly have done? He's in the Diddy stuff?
He got a 41 count indictment.
Cash out. And he's a rapper?
His name is Cash Out. Mm-hmm.
Wait a minute, cash app or cash out?
Cash Out.
I ain't hear nothing about that.
Yeah. Let me take. I ain't gonna do Nation Boy tonight. But yeah, honey, that's crazy. I'm just like all this exposure. Lord, you know I'm sleeping. You know I can't even formulate my words. All this exposure
Oh,
of
he's from Atlanta?
these guys having sex with other guys, huh?
Um, a rapper who scored a pair of billions and platinums and gold hits. Let me see, what do they say? He's accused of using his celebrity status and social media as means to lure women. According to prosecutor, he and others used a hotel room near Fulton Industrial Boulevard and a residence in a city Carroll Heights neighborhood to carry out crimes. Cash Out soon after took to Instagram story to clear his name with a message that called for his name to be cleared. Okay, so what else he do?
Some as a prostitution.
There's gotta be more to this.
It's a 41-page indictment, and I can't. I gotta find out where it is. Did they say is that article you read, does it tell you is it a county or
Um, Let me see what TMZ says. They say 41 count indictment that includes allegation of rape, aggravated sodomy, human trafficking, and even holding victims at gunpoint.
Mm-hmm.
He's facing 25 to life. And it's another person, she twerking. I guess it's part of the indictment. Cashing out and she twerking is facing 25 to life. Mm. So that's what I'm saying. All these sex trafficking,
Yeah.
RICO.
Mm-hmm.
And I'm trying to figure out where's the
Yeah.
white guys, the white entertainers. They don't do freaky stuff.
Well,
They don't have dungeon
they
parties.
got some. They catching some of them rock and roll people, but I don't see them on no Rico because they look like they hitting everybody, all the black people with the Rico.
What white people you seen
We get
them
hit with
bringing
the
charges
Rico.
against on sex crimes?
It's a few. I can't. They got some of them bands. I don't know. I'll
I
have to
know a couple of
Google.
months ago, the only one I remember hearing about, I think his was a sex crime. What's the guy's name that played on oh God. The one where the guy died. Oh my Jesus. Paul Walker. Damn it. What's
Fast
the
and
name of
Furious.
the Yeah, Fast and Furious. The what's his name? The white boy, the cute one, the muscle, the leader, the star
Vin
of the show.
Diesel.
Yeah, didn't he have something that came out on
Yeah,
him a couple of
I
months
think
ago?
so. Yeah. Mhm.
But that was hushed up real fast. I think they talked about that about 3 or 4 days.
Mm.
They said he was luring women into prostitution. Ah, well, I guess that's the sex trafficking.
Mhm.
Yeah, indictment on rape, sex trafficking, luring women into prostitution. Wow. See, that's what. Okay, so when they speak of those charges like that, they're not saying they're actually sending them out on the street to prostitute to bring them back money like a pimp. They're just saying they're passing them around to their friends and giving them lavishing gifts or money, right?
Mhm.
Okay. Hmm. So
That's some
being a
good
sugar
time.
daddy now is considered being a pimp. Because in our days,
You
that's what we
think so?
called it. Huh?
Your sugar daddy?
That's what we used to call them. If you date a man older than you, even if you was at legal age, excuse me, that was my sugar daddy. If I was 23 and he was 40, I got a sugar daddy.
Mm.
That's what I would call him. I didn't call him my pimp. That's because that sugar daddy
Mm.
had a job. He had a car. He had his own place. He took me out. He bought me clothes. He bought me dinner. He gave me money. That was my sugar daddy because he was older than me. Hell, if I had someone, if I was 23 and he was 27 and he did all those things that a man's supposed to do and take care of his woman, I'd probably call him sugar daddy. Well, I probably would just call him daddy. But if he was older, it would be a sugar daddy. So that's why, when they say Kale's wanted people to call his woman to call him daddy, ain't nothing wrong with that. We've been doing that since the beginning of time. That's like that was
Oh, I
nothing
don't know
new
about
for a
that.
woman to call. I think people still call their husbands daddy. Monique do, you know. It just it's just a term of endearment.
Mhm.
Like our husbands might call us sweet cakes, you know, or mama. There's nothing wrong with that. What do we call people now? Bae, 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 bae. Everybody call people bae. It's the same thing.
I can do the bae. I can do that, but I can't do no daddy.
Why
I'm not doing
not?
daddy
Okay,
or
Miss
zaddy
Angie,
either.
you got this
I'm not
fine man that you in love with. He do everything right. Make love to you, wine and dine you, treat you like a queen. And I mean, we know it ain't your daddy. It might be weird for some people, depending on if you got daddy issues or if you got a good daddy and nobody could compare to your daddy. But take away your father figure. This is your man that's taking care of you like he was your daddy. And you get accustomed to calling him daddy. Thank you, daddy. He bring you a gift, some jewelry. Thank you, daddy. You know, it's just a term of endearment. I don't look at it no other way. I'm not looking at it like I'm screwing my daddy. I'm trying to replace my daddy with him or replace him with my daddy. Like that's just I don't know. I don't know. Just my thought. Who's
no,
celebrity outlaw?
I don't care what you doing. I'm not calling you no zaddy, no zitty, and none of that shit. I'm not doing none of
So
that
you never gave a pet
trying to
name to
be cute
someone?
shit. I'm not doing that. That's
Miss Angie,
crazy.
you never
I'm not
gave
doing that.
your boyfriend or your
Zitty.
husband a pet name?
Yeah, it wasn't on no zitty and all that shit. No.
So
Yeah.
what's the okay? Did they ever call you mama? Hey, sexy mama. Hey, pretty mama. Sugar cakes.
No.
You didn't have no pet names?
Let me see. Not like that.
Sugar bear, sugar plum.
Uh.
I
No.
don't know. Like I said, I mean, I was raised by my grandmother, so maybe that's why I got an old mind or old soul. It's just like I said, when I was growing up, yeah, and you did right by me, you were my sugar daddy. And it didn't matter how old you was above me, because like I never dealt with anybody younger than me because they couldn't do the things that I wanted. You know, I had in my mind, like I said, I was around a lot of older women, and you hear, don't
No.
why buy the milk? Why
I'm not doing
buy the
all
milk
that,
if you get
honey.
why buy the cow and get the milk for free, right? So if I'm giving you something,
I
you
don't do
know,
that. Uh,
what you giving
Go ahead.
me? I know how to satisfy myself. I don't need you for nothing. And I'm sure men can satisfy themselves, but they still want more. We can satisfy ourselves and be good, go to sleep, smoke a cigarette, have a drink, and be snoring in 10 minutes, taking care of ourselves. But a man can't. So, yeah. I used to think like if I was to do something with someone, but that's why, well, that was kind of why I dealt with older men too, because I knew most of the time older men don't talk. Um, but if I'm with someone and they
Girl.
happen to want to tell my business, well, you told what we did.
It's
Did
so
you tell them what you
much.
gave me for it?
You're like, what do you make of all this stuff that keeps going, all this stuff
Huh?
that keeps coming out with these stars and stuff? Like, what is the problem? Hold on.
With my thoughts?
Yeah, hold on. Who
Miss
is this
Hitchy,
woman in the United States? Yeah,
what are you talking about?
you already told me that, but who is this celebrity?
That's what I was asking you, but you didn't answer
No, I
me.
said, what was the thoughts about? No, no, no,
I thought you were asking me where did I come
I'm
up with
talking
all
about
these
all these.
things in my head.
No, I don't ask you that. No,
Is
he
this
said
a,
the celebrity outlook. United States Court of Appeals for the Seventh Circuit opinion number 23, similar since error as RSK. United States Court of Appeals for the Seventh Circuit opinion is similar since error. Please review. What was that?
well,
You see them people in the chat?
I see his message. He's saying whoever's case this is, he's saying there's the same similar sentencing error as Kel's. That's the only I don't see him nowhere else in the chat. He just popped up. Can you pull up that what is it called? Appeal? Does it look familiar?
Yeah, I can.
What is the seventh circuit? What's that? Higher court? I'm trying to figure out if he's for or against. Is he giving us some helpful information?
I don't know why I'm buffering.
What, you can't hear me? Can you hear me, Miss Angie? Can the chat hear me? Blessings, Karen J. Stevie talking about he listening. He ain't listening. He's asleep. Miss Angie.
Can you hear me cooking?
Can you hear me? You can't hear me?
I can hear you now. Can you hear me?
Yes, ma'am.
Okay.
So did you figure out what that person was talking about?
That's what I'm looking for now.
Mm. He came out of nowhere. Celebrity Outlook. What is Celebrity Outlook? Are you a reporter? Are you a judge?
They just started this channel today.
What?
Mm-hmm.
So you think it's just someone playing games? Or they trying to get some helpful information out there? What was that guy's name that was Snow? Something Snow. Remember years ago?
Don
Oh,
Snow.
what did he do?
Yeah.
Wasn't he
Don
like a
Snow.
spy? Or he gave us some information on us, right?
He locked up.
I thought he was out. I'm not
That
talking
young
about
boy.
that. I'm not talking about that guy from YouTube. I'm talking about years ago. Remember he got extradited or he left the country because he was like a spy. I think his last name was Snows. Sheldon Snow. You don't remember that years ago, like in the early 2000s?
Wh- What
I
happened
forget.
now?
He was like a spy. He was either spying on us. He gave us some information. He was, what do they call it when you tell on somebody? Politic wise.
Mm. I
Oh
don't know.
Jesus, I hate when I go stupid like this. Oh my God, what is it called when you tell but you do it behind the scene so nobody know that you're telling? Like if you tell something that the president's doing and you send a letter to the reporters or something. What's that word they use? Oh Jesus Lord.
Mm. I don't know. Mm. 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 Girl, my behind is sleep.
You're
Ooh.
sleepy. I'm gonna let you go because now I'm curious to know who the celebrity person is.
I don't know.
When if
Audrey, is that you?
I know, right?
Mm.
Well, did you find? Is it a woman that you seen?
It don't tell me if it's a woman or a man. It tell me when they open their account.
Because when I looked it up, a woman popped up. She got 136 followers, 49 videos, and
Mm.
she says, "I make short videos on your favorite celebrities."
No, did you go to? I don't know what you looked at.
I
Did you go on
googled.
YouTube? No. Okay. I go to the. I push on. I I look at the
Okay, keep your
YouTube.
secret. You ain't got to tell me.
No, no, everybody do it. They just click on go to channel and it tell you when they
Oh, like if you searching for somebody's channel.
yeah.
Oh, so you
You
went
just
that
go to
route. See, when I found it, wait a minute.
no, if you just get
Oh,
it
I
off
see.
of
2
YouTube.
subscribers. So, if you want to tell us some information, Mr. Celebrity or Miss Celebrity, tell us. What are we looking up?
No, you just go on YouTube. Just why you like
No,
when
I'm
you
talking about what
check,
they're talking about with the appellate court people.
you just look up that court number, that case number, opinion number.
You look it up where?
You have to go and you got to go and paste or look it up.
I don't have that stuff yet.
Oh, well, I got it. I can look it up. Mm-hmm. Unless you're talking about how to look at a channel.
I'm curious to know
But
what they're
you
talking
know what
about.
trips me out? I can't stand for somebody to talk about my skills, but yet repeat what I say about the law or whatever I say. Like, shut up! You sound stupid. If you don't talk about my skills and then repeat what the fuck I say, no, you come out here and present the law. You come out and present the law. Because the next time I hear somebody repeat what I say that I don't fuck with that and came at me, I'm gonna tear their ass up. I'm gonna make sure I have some sleep, and then I'm going to rip their ass apart about the
No,
law.
you know what you should do, Miss
Yeah,
Angie? You should give out false information and then let them repeat it. And then be like, you've been pranked.
yeah, that'd be funny. That'll
And then
stop
that
them.
way they'll stop doing it because they won't know when you're serious or not.
Hmm. That'd be funny. Hmm.
I am really curious to know what they're talking about. We need Miss Queenie E up in here.
I want to find this other account, but this Cash Out man, he got songs with Future. Hmm.
He got something with Future.
I ain't never heard no rap named Cash Out.
Me neither. And what was the person's name? Somebody twerking.
Mm-hmm. Mm-hmm.
He's 33.
Mm-hmm.
He's from Atlanta, Georgia.
But you Googling, but you don't know if that's the right person.
It says he's a rapper.
Oh, you talking about Cash Out. Oh, okay,
Uh-huh.
yeah.
Yeah. It seemed like he's been. He's my. I want to hear what his music sound like. And I'm like, what the hell they talking about? Cause boy, you know I'm cashing out. Been around with a girl named Nina.
Who is that? That's the Cash Out man.
Uh-huh. You hear it?
Okay. Mm-hmm.
Ain't my kind of music, but we got a nice little beat to it. Almost all of his songs sound like that. 2022, a lot of his videos is, but then he got one in 2012. That was the one I played. 2018. Did you find it, Miss Angie?
Hmm?
Did you find it? Are you looking for
I
that
didn't find
thing?
his case. I didn't find his case, his indictment yet. I found Nature Boy's indictment, but
No,
I
I'm trying to.
haven't
I'm
found.
still trying to figure out what Celebrity Outlook is talking about. Similar sentencing era. So I want to know whose case he's referring that to. Kel's. So the opinions number, would that be that it happened in 2023 also?
23 is when the appeal was filed.
Uh, but it could still be like an old case
Yeah.
years and years ago.
Mm-hmm. Well, girl, let me get out here because I am about to. I'm about to fall asleep. I'm gonna try to come back tomorrow so I can do Nature Boy and who else I said? I gotta find this Cash App dude. Cash Out. But he's supposed to be a kind of big deal, girl. Cause he got. I mean, you see the list of the people he don't work with.
Well, maybe that's the problem. That's probably how he got caught up. He might be in there with Diddy somewhere.
But he got a like prostitution, girl. Like, god damn.
Okay, Miss Angie, I hope I see you tomorrow.
Yes, ma'am, Miss Cookie. I'm gonna try to make that for you.
Okay, get you some rest, okay?
All right. You have a
All right, good
good
night.
night.
Love you.
Love you, honey. Sweetie.
Bye-bye.
Bye. Bye, y'all.
Good night,
Thank y'all for
chat.
coming on through. Thank y'all. Y'all always hold it down. No matter who it is, y'all always somebody out there on the night shift holding it down for us. Y'all, I can't do it tonight. I was out of it when I clicked the link. So, but I tried. I'm sleeping. So hey, I will talk to y'all later. Make sure y'all do something good for yourself or somebody else. Keep everybody in this section in prayer. And I will talk to you at a later date. Peace out, y'all. Love you. Be safe.